Good morning, everybody. Happy Monday. A little early start for TCF Live this morning. We'll start our day in Royal Oak, Michigan. This is the 44th District Court Magistrate.
Yes.
Good morning, Ms. Baez. Today's date and time set for your informal hearing. Ms. Baez, these are civil proceedings of a non-criminal nature. Nobody's going to jail this morning on these traffic tickets. In fact, both of these appear to be documentary in nature. But they are important enough that Officer Francis did issue you the citations on the date in question. That date, Ms. Baez, was January 23rd of this year at about 20 minutes of 9 in the evening. You were operating a 2023 black Tesla Model 3 on 6th Street at or near Center in the city of Royal Oak. At that place and time, you were cited for disobeying a stop sign and for having no registration on your person. So one of these is a moving violation. The other one is documentary. And you have three options to protect your own rights, Ms. Baez. You may admit responsibility to these citations. The court will attach a fine between 0 and the maximum, and that will close the case. You could admit responsibility with an explanation that you believe mitigates your circumstances. That could obviously include displaying an updated registration as well. Or you have every right to deny responsibility. If you do so, we will conduct your trial forthwith. The court will swear the parties under oath. The officer will testify first. Then you will testify, and then the court will make a finding of responsible or not responsible based upon the civil burden of proof, a mere preponderance of the evidence. So as to no registration on person and disobey stop sign, do you wish to admit and explain, or deny responsibility?
And explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the city of Royal Oak. You did not have a current registration on your person at the time of the request, and you did disobey a stop sign, correct?
Yeah, I guess I stopped, but he said I didn't stop long enough. So
Okay. Well, I don't want you to do anything you don't want to do. So
no, I mean that's my explanation is I didn't like
the
it
motor
sounds
vehicle
like
code says full stop, but if so do you wish you want to take responsibility for that?
Responsibility with explanation, yes.
Thank you. What if anything would you like to tell the court, Ms. Baez?
I do have my registration, so I can show that.
Okay, that's great. Go ahead, and if you have that, you can hold it up to your device and say your name, please.
Netta Hussein Bays.
Thanks. Officer Francis, can you make that out?
Maybe I have two of them.
Unmute, please, officer.
It shows up backwards.
Officer Francis, can you unmute?
Sorry, long night last night. With
fine.
that being said, yes, I'd like to dismiss that portion of the citation.
Okay, so the registration on person is dismissed. And with respect, go ahead.
Oh, for the violation, the traffic. Yeah, I guess maybe I have a Tesla. It's a one brake situation. I mean, it's a one pedal situation. So I removed my foot off of the gas, and maybe it wasn't long enough. I have my daughter's type 1 diabetic, and I have an alarm that goes off when her blood sugar is really low. So maybe that went off at the same time. So maybe it was like a momentary thing that I didn't stop long enough. Because I was trying to, and then I was going to stop to, see what was wrong.
Understood.
The
young people call that a California roll, but it's important to come to a full stop safely when we can. Officer, anything with respect to the stop sign?
Yes, Your Honor. I'd like to make the motion to amend that to impeding traffic.
Okay, Ms. Baez, the impeding traffic offense is a 0-point violation, will never appear on your master driving record. That's acceptable to you?
Yes, it is.
Thank you very much. So your original plea subsumes a plea to impeding traffic. The sanction is $175 that is payable through the pay portal on the 44th District Court website. Or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 14 days. Just get a little bit more familiar with that vehicle of yours, and I hope your daughter's doing well. Take care.
Thank you. Okay.
Calling case number 26 RO00519. This is People versus Sherian James Coachaparampil.
Yeah, it's a little hard. My last name is Coachaparampil, but it's fine.
Coachaparampil.
Yeah,
All
close.
right, sir.
Yeah.
Welcome to 44th District Court, Mr. Coachaparampil. Today's date and time set for your informal hearing. An informal hearing is a non-criminal proceeding. Nobody's going to jail today on this ticket. However, it is considered serious enough that the officer issued the citation on the date in question. And that date was, Mr. Coachaparampil, January 27th of this year at 8:02 in the evening.
Yeah.
You were operating a 2019 Subaru Crosstrek, white in color, on 11 Mile Road, Editor, Washington Avenue, in the city of Royal Oak. At that place and time, you were cited for disobeying a traffic control device. The officer's remark showing on your ticket indicates observed vehicle northbound on Lafayette, turn eastbound, or right onto 11 Mile Road. And it is posted no turn on red there. Officer Francis, if the court recalls, that's just opposite of the McDonald's, right?
That is correct.
All right. So, Mr. Coachaparampil, the citation is for disobey traffic control device. You have three options to protect your rights. You may admit responsibility in this matter. You can admit and explain, or you have every right to deny responsibility, and the court will swear the parties under oath. We will conduct your trial forthwith. The officer will testify first, then you are to testify, and then the court makes a finding of responsible or not responsible. But please remember, because we're in civil court, that burden of proof is a mere preponderance of the evidence, otherwise known as the featherweight test. So as to disobey traffic control device, do you wish to admit and explain, or deny responsibility?
I'll admit that I.
Thank you very much. So you wish to confirm that on the date in question, you were operating a motor vehicle in the city of Royal Oak and intentionally or otherwise disobeyed a traffic control device, correct?
Yes, I didn't see the sign, so I went back and I saw the sign. I was like, oh, okay, it's there.
Well, the court is grateful for your honesty. Honesty is always the best policy. Frequently, and this is a safety tip that applies to everybody, including this court, it's always a good reminder. Frequently, when we think we're going to be making a right turn, we'll skinny up a little bit further on that intersection, and we might actually pass the signage.
Yeah.
So if you start getting way older, like the court does, you'll find yourself in a circumstance where you almost want to back up to make sure you're not doing the wrong thing. But
Yeah.
then again, you can get cited for improper backing. So the rule of thumb is always take your time, always be mindful. So the court is grateful for your candor. And Officer Francis, what would you like to share?
Yes, Your Honor. Obviously with the honesty and a very good clean driving record, I'd like to make the motion to amend this to impeding traffic.
Okay. Mr. Coachaparampil, impeding traffic is a 0-point violation. Your master driving record, that's acceptable to you?
Yes.
Very well. Your original plea subsumes a plea to impeding. The fine is $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's going to be due within 14 days. That completes your hearing. Just always be mindful of the signs and the stripes and the signals. Take care.
Yeah. Thank you. Yeah. I didn't notice it until it was on a curve, so I was like, I went past it and I didn't see it. So
We get you. All right. You take care now, sir.
Morning once again, everybody. It's a mischievous Monday here at TCF Live. Ellie just disconnected half of my stuff, but the stream still kept going, and I managed to rebuild everything, and she is now banned from being up here. But it looks like she's doing biscuits on her bed down by my feet, so hopefully she just sleeps it off. All right, let's go to Allegan County, Michigan. This is Judge Scoselis.
Yes, sir. I was in
This
the wrong.
morning you signed this, pardon?
That I was in the wrong. I know that. And I went and got everything taken care of right after. So
On February 23rd, you signed this yellow advice of rights sheet. Before you signed that sheet, did you read and understand all those rights?
yes, sir.
Those are your trial rights. If you plead guilty to all three of these cases, you will not have a trial of any kind, and you'll be giving up all those trial rights, including the right to have an attorney represent you. Do you understand that?
Yes.
Has anyone promised you anything regarding what your sentences will be if you do plead guilty?
No, sir.
Anyone threaten you to force you to do this?
No, sir.
Is it your choice to plead guilty?
Yes, sir.
And are you pleading guilty to these charges because you believe you're guilty of these charges?
Yes, sir.
Again, all three of these files were initiated through citation issued by the Allegan County Sheriff's Department. This dates on February 16th of this year at approximately 8 o'clock in the morning. You operated a motor vehicle on 124th Avenue, Wayland Township, here in Allegan County. Were you operating a motor vehicle on that date and at that location?
Yes. So, I was on my way to work and I pulled into the parking lot, and that is when he flicked me.
Were you operating a 2002 Chevrolet?
Yes.
The first allegation in the citation is you failed to transfer vehicle title within 15 days. When did you purchase that 2002 Chevy?
My girlfriend purchased that earlier in the summer because she was going to use that to run the mail route. And then I had a truck, and then the transmission went out not too long ago, so I just started driving that back and forth. We just moved into her parents' house to try to save some money up. And I just haven't getting plates and stuff on the vehicle yet.
So this was your girlfriend's vehicle.
Yes, and I was driving it.
Did your girlfriend have on her vehicle?
Yes.
Okay, I'm not sure what's going on here then, because they're charging you with being the owner of the vehicle, not transferring title within 15 days after you purchased it. I haven't even heard that you purchased it, just that you're driving around your girlfriend's car. So can you screen him for an agency before we go? Because it sounds like we've got some issues here on all three of these, given this is probably a ticket that should have gone to his girlfriend and not to him. In any event, Mr. Boone, we're going to have the public defender talk to you further on these three cases. Don't go away. He'll be in a breakout room with you after he takes care of some other cases, okay?
Okay.
Thank you.
Yep, thank you.
Antero Solomon Borja, this is 260494FY. This morning for arraignment, charged through a felony complaint issued by the Allegan County Prosecutor's Office on a charge of carrying a concealed pistol in a motor vehicle. Count 2 is a misdemeanor firearms charge as well. Mr. Badger, please.
Sam Badger appeared on behalf of Mr. Borhoff for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. He does qualify for a court-appointed attorney, and we request that this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
And count 1 is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set this for you within 2 weeks. There are no dates in the file, Kelly.
Probable cause will be on the 19th.
Your probable cause conference is a week from Thursday, which is March 19th at 1 p.m. and that will be in District Courtroom D. Preliminary examination itself is the following Wednesday, which will be the 25th of March at 9 a.m. in this courtroom, District Courtroom A. Court file shows you posted a $1,000 surety bond for your release from jail. Bail will be continued in that amount. Condition of your bail due to this charge is you not be in possession of any firearms while your case is pending. Public Defender's Office has determined appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your next court appearance. Again, your next court appearance is a week from Thursday at 1 o'clock in the afternoon. So you are free to hang up the court proceeding today. Okay?
Okay.
File 260517 FY, People versus Philip Lee Picken. Here this morning for arraignment charged through a multi-count felony complaint issued by the Allegheny County Prosecutor's Office. Count 1 is a charge of making a false report or threat of terrorism. Count 2, a charge of malicious use of a telecommunications service. And count 3, malicious use of a telecommunications service. Mr. Badger, please.
Thank you, Your Honor. Sam Badger, appearing on behalf of Mr. Picken for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He does qualify for a court-appointed attorney, and we would request that this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
Yes, sir. Count 1 is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set that for you within 2 weeks. Your probable cause conference is a week from Thursday, which is March 19th, and that will be at 1 p.m. in District Courtroom D. Preliminary examination itself is the following Wednesday, March 25th at 9 a.m. in this courtroom, District Courtroom A. Bail was set at warrant authorization at $20,000, cash or surety. Court file shows you posted a $20,000 surety bond. Our Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your probable cause conference. Again, that's set for a week from Thursday at 1 o'clock in the afternoon. So you are free to hang out from the court proceeding today. Be expecting contact on that date from an attorney from the Public Defender's Office. Okay?
Okay.
File 260519 OM, Harold C. Swanson, here this morning for arraignment charged through a city ordinance for trespassing. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Swanson for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading. He is entering a plea of not guilty, and he does qualify for a court-appointed attorney. And we request that this matter be set for a pretrial and a jury trial, Your Honor.
Not guilty plea, set this for a jury trial. Indicate you're requesting an attorney at public expense. We'll set bail in this charge at $300 personal recognizance. The case will be set first for a pretrial conference that will be with the Allegan City Attorney. If not resolved, it'll be set for a jury trial in this courtroom, District Courtroom A. Public Defender's Office has determined you are indigent, and they will be appointing an attorney for you at public expense. So an attorney from the Public Defender's Office will discuss your case with you at the date and time of your pretrial conference. The date and time will be sent to you by the clerk's office in the mail, so you are free to hang up from the court proceeding this morning. Be expecting that in the mail. Okay?
Thank you, sir. God bless you.
About 260543 ST, People versus Colin James Vandermoor, here this morning for arraignment charged through a citation issued by the Allegheny County Sheriff's Department on a charge of fleeing the scene of a property damage accident. Mr. Badger, please.
Thank you, Your Honor. Sam Badger appearing on behalf of Mr. Vandermoor for the limited purpose of arraignment. We have reviewed the charging document and waive its formal reading, and Mr. Vandermoor will be pleading guilty this morning, Your Honor.
Mr. Vandermoor, is that what you've agreed to do?
Yes, Your Honor.
Okay. Charge is a misdemeanor charge, carries a maximum penalty of 93 days in jail and a $500 fine. Knowing that, do you still wish to plead guilty to the charge
Yes,
of
Your Honor.
fleeing the scene of an accident?
Yes, Your Honor.
If you do plead guilty, you will not have a trial of any kind, and you'll be giving up all the following rights. First, the right to have a trial by a jury or a trial by a judge without a jury, and that would be at your choosing. You'd also have the right to have an attorney represent you in this case. If you cannot afford one, you could request one at public expense. At a trial, if you had one, you would have the right to call witnesses to speak for you on your behalf. If you needed assistance to get those witnesses to court, I would order them to appear on your behalf. At a trial, if you had one, you would have the right to see, hear, and question all the witnesses that were called against you. You'd also have the right at a trial to testify yourself or to not testify and remain silent. If you chose not to testify at your trial, the prosecutor could not comment on that fact before the jury. Finally, if you had a trial in this case, you'd have the right to be presumed innocent until the prosecutor proved beyond a reasonable doubt that you were guilty of this charge. And sir, do you understand those rights that I've read to you?
Yes, Your Honor.
Those are your trial rights. But if you plead guilty, you will not have a trial and you will give up all those trial rights. Do you understand that?
Yes, Your Honor.
Has anyone promised you anything regarding what your sentence will be if you do plead guilty today?
No, Your Honor.
Are you currently on probation or parole to any court?
Yeah, I'm on probation.
If you plead guilty to a new criminal charge while you're on probation, that's an automatic statutory violation of your probation, and you could be imprisoned or jailed on a probation violation. Knowing that, do you still wish to plead guilty?
No, Your Honor.
Okay, we're going to have you talk further to the public defender's office. He's got some other people to talk to. He'll come back to you in just a bit. So don't disconnect from the court proceeding. He'll talk to you in a few minutes, okay?
All right.
260511FY, People versus Garrett Hosea Wigmink, here this morning for arraignment charged through a felony complaint issued by the Allegheny County Prosecutor's Office. And this is on a charge carrying a concealed weapon in a motor vehicle. Mr. Badger, please.
Thank you, Your Honor. Sam Badger, appearing on behalf of Mr. Wigmink for the limited purpose of arraignment. We have reviewed the charging document and waived its formal reading. He does qualify for a court-appointed attorney and request that this matter be set for a probable cause conference and a preliminary examination, Your Honor. Thank you.
And sir, this is a felony charge, and in district court, you are entitled to a preliminary examination on a felony charge. As required, we are going to set this for you within 2 weeks. Your probable cause conference is a week from Thursday, March 19th at 1 p.m. in District Courtroom D. Preliminary examination itself is the following Wednesday, March 25th at 9 a.m. in this courtroom, District Courtroom A. Be able to set a warrant authorization at $1,000 cash or surety. The court file is showing you posted $1,000 in cash. Public defender has determined you're indigent, and they will be appointing an attorney for you at public expense. So an attorney from the public defender's office will discuss your case with you at your next court appearance date. Your next court appearance date is a week from Thursday at 1 o'clock in the afternoon. So be expecting contact on that date from an attorney from the public defender's office. Okay.
Yes, thank you. Thank you, Your Honor.
Have two files on Eddie Enrique Concepcion, 260532SD X4645562BSI, both based on the same citation that was issued by the Michigan State Police on charges of fleeing the scene of a property damage accident and a civil infraction for failure to stop within an assured clear distance ahead. Notice to appear was sent for today on February 19th for today's date at 8:30 in this courtroom. It's now 9:06. We've had no contact from the defendant. Both charges are non-assaultive offenses and did not see any prior non-appearances in this case. Given that, we will hold these for a period of 48 hours before any bench warrant is issued. Now 260384 SD, People versus Ryan Douglas Kuistra. Also set this morning for arraignment at 8:30. This is on a charge of operating while intoxicated. This to appear went out on the 17th of September for today's date at 8:30 in this courtroom. It's now 9:06. We've had no contact with the defendant. Again, this is a non-assaultive offense. Do not see any prior non-appearances in this case. So again, we'll hold this file for a period of 48.
And I guess we're done with him. All right. Good morning once again, everybody. Happy Monday, TCF Live. Good to have you here. I have managed to rebuild everything that Ellie knocked loose a little bit ago. But I just realized something. So the entire world time changed except here at the bunker, which is located in Arizona. We don't time change because we're rational, sane people here in AZ. But it means that we're doing this show an hour earlier, which means Ellie's schedule is also messed up. She's usually playful during this time, so I think that was part of the problem she's going to have to adjust. Anywho, let's move on. Huron County, Michigan. This is Judge Gerald Prill.
Here are two files, 267419 and 7420H. Time and date set for arraignment. Mr. Cook is present, represented by Attorney Elizabeth B. Weisenbach. People are represented by Prosecuting Attorney Timothy J. Murkowski. Ms. Weisenbach, have you received a copy of the information, respective information filed in these matters? Have you had the opportunity to review them with your client and you waive the readings as well?
Yes.
Sounds like there's a plea offer here. Is that correct?
Yes, sir.
Mr. Cook, as best you can, would you please raise your right?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Mr. Murkowski, would you please state the terms of the plea offer?
Yes, Your Honor. In 307419, Mr. Cook would be pleading guilty to absconding on bond and tampering with electronic device. Habitual offender fourth. People agree not to request consecutive sentencing. He agrees to pay full restitution if applicable. And this file is also a package offer with the other file, which is 307420. In that file, Mr. Cook would be pleading to resisting, obstructing, and being habitual offender fourth offense.
All right.
Pay full restitution if applicable.
Ms. Weisenbach, is that your understanding of the plea offer?
It is.
Mr. Cook, did you hear the terms of the plea offer outlined just a moment ago?
Yes, I did.
Is that your understanding of the plea offer? Did you wish to accept it?
Yes, I did.
Are there any other terms to the offer that we've not covered on this record?
No, there's not.
Ms. Weisenbach, do you agree?
Yes.
Mr. Murkowski?
I agree.
Thank you. Mr. Cook, are you on any term of probation or parole?
No.
Have you had sufficient time to talk to Ms. Weisenbach about this?
Yes, I have.
Do you need any additional time to speak with her? No. Is there anything affecting your mind or brain making it difficult to make important decisions? You have a clear mind?
Yes, I do.
Very well. As to the charges contained in 7419 alleging on or about January 28, 2026, in the city of Bad Axe, well, let me back up a bit. In 7419, you were charged with absconding on bond. You're also charged in count 2 with tampering with evidence, both habitual offender fourth. Resisting, obstructing in the second file, you're charged in that matter as well. Habitual fourth as well. As to absconding or forfeiting bond, the maximum sentence with habitual fourth would be up to 15 years in prison and or a fine of up to $5,000. Do you understand the charge and maximum sentence relative to that?
Yes, I do.
In count 2, you're charged with tampering with electronic monitoring device, habitual offender fourth. That is also a felony carrying a maximum prison sentence, again of up to 15 years and or a fine of up to $4,000. Do you understand the charge and maximum sentence regarding that matter as well?
Yes, I do.
Backing up on the absconding or forfeiting bond, in that matter, though the prosecutor has stated they're not seeking consecutive sentencing, you could face consecutive sentencing. Do you understand?
Yes, I do.
All right, you wish to proceed in light of that?
Yes, I do.
Very well. In 7420, we're charged with resisting or obstructing a police officer, habitual offender fourth. Again, that is a felony carrying a maximum prison sentence of up to 15 years and/or a fine of up to $2,000. Do you understand the charge and maximum sentence regarding that matter as well?
Yes, I do.
Okay. Understanding all of that, then, how do you plead then to absconding bond and tampering with evidence on or about January 28, 2026 in the city of Bad Axe, County of Fury? How do you plead to resisting or obstructing a police officer on or about January 31st, 2026, city of Bad Axe, County of Fury? You acknowledge being previously convicted in this court on March 9, 2020 for assault with intent to do, assault by strangulation or great bodily harm.
Yes.
You also acknowledge on January 10, 2017, you were convicted of escape from an official detention in the county of Jasper, state of Wyoming.
Yes.
Do you acknowledge being previously convicted on or about November 13, 2014 in Lander, state of Wyoming, 9th Judicial District Court for theft or larceny?
Yes, I do.
You acknowledge on that same date, November 13, 2014, being convicted of the offense of theft, larceny in the 9th District Court for the county of Fremont, state of Wyoming.
Yes, I do.
So this will be your 4th felony conviction at least, correct?
Yes.
Ms. Weisenbach has provided the court with separate advice and rights forms. They're dated March 8th. You signed these documents, sir?
Yes, I did.
Now, before signing them, did you read them?
Yes, I did.
Did you also go over them with Ms. Weisenbach?
Yes, I did.
Do you understand the rights contained on the form?
Yes, I do.
By entering guilty pleas, you're giving up all those rights. Do you understand that? It means you will not have a trial of any kind or have any opportunity whatsoever to contest your guilt. And all that remains after today will be for you to be sentenced. You understand that?
Yes, I do.
If these pleas are accepted, you'll be giving up any claim that these pleas are the results of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim this pleas out of your own free choice. You understand that as well?
Yes, I do.
Other than the terms of the plea offer outlined on the record, has anyone promised you anything such as leniency to keep you plead guilty? Do you understand that no one can make any promises from the court as to how the court will dispose of this case, these cases, that is? That no one can promise that the court will be easy on you in imposing a sentence. Do you understand that?
Yes, I do.
Has anyone promised the court will be easy on you?
No.
Has anyone threatened you to enter these pleas?
No.
These pleas of your own free choice?
Yeah.
There are court costs that are due and payable at time of sentencing unless there's good cause shown. Are you aware of that?
Yes, I am.
And that you're subject to a 20% late penalty for any unpaid court obligation due 56 days following your conviction and sentence. Do you understand that?
Yes, I do.
Finally, if these pleas are accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeals from the convictions and sentences pursuant to these pleas will be by application for leave to appeal and not by right. Do you understand that, sir?
Yes, I do.
Any question regarding any of your rights? Any questions of your attorney? Ms. Weisenbach, I'll allow you to establish a factual basis.
All right, thank you. I will start with 26307-419F8. So this is the bonding time that you're supposed to be in court on January 28th, you recall that, correct? We had met like a day or two before that. We had gone over all of the information we're supposed to be in district court, right? And you did not appear, correct?
I'm sorry, I didn't hear the answer.
I said yes.
Okay, thank you.
Was there some kind of an emergency or just chose not to appear in court? There was a time that you also had on your cell phone an application that was used by district court to keep track of. Is that correct? That was something that you had signed up for and that you had to put onto your phone, correct? There was a time when your phone had a problem and it reset itself, correct? A lot of your applications were lost and you had to put some things back on your phone, correct? Did you put the application back on from district court that you ordered to have? Okay. The police report indicates that Ms. Wood, who's pretrial services, did not have the ability to check your location using that cell phone application. Is that correct? So it would have been that you did not install that app, right? You would order to do. Okay. And all of this happened in Karen County, correct? I believe that that's the factual basis for 7419.
Any objection, Mr. Counsel?
No, Your Honor.
Thank you. You may proceed, Ms. Wiseman.
Thank you. And then, as a result of that, the police went to contact you. Is that correct? So on January 30th this year, police officers saw you outside of Northgate Tire here in Maddox. Is that correct? And did you respond to them appropriately and go peacefully with them when they were meaning to arrest you for this bond absconding? Did you run away from them? Did they call for you? Did you hear them? Did you see that they were police officers? And you knew who they were too, didn't you? Okay, so you knew that there was one police officer indicating that you need to go with him, correct? You failed to follow that reasonable command, right? Okay. That is in your account, correct? I have nothing further.
Any objection to the factual basis, Mr. Rutkowski?
No, Your Honor.
Sir, are you aware of any promises, threats, or inducements for these pleas other than what's been disclosed?
No, Your Honor.
Ms. Weisenbach?
No.
Has the court complied with the court rule concerning pleas, Mr. Rutkowski?
It has, Your Honor.
Ms. Weisenbach?
Yes.
Mr. Cook, there's no agreement made by this court concerning the plea and what the final sentence will be. Is that accurate?
Yes.
Ms. Weisenbach, do you agree?
Yes.
Mr. Rutkowski?
Yes, Your Honor.
Court will accept the pleas. They're done freely, they're voluntary, they're understanding and accurate. There is a sufficient factual basis. Court will accept the pleas and schedule sentencing for it.
Your Honor, Mr. Cook is scheduled for sentencing on the file ending in 386, 387, and 345 on all April 6th. We're asking if the court has any objection adding these dockets to that motion day and to have everything in one report.
Ms. Weisenbach, any objection to that?
We had been hopeful of keeping the April 16th date. Yes, no objection.
All right, Mr. Rutkowski?
No objection.
Court will schedule sentencing April 6, 2026 at 9 a.m. Prior to sentencing, the court will order a pre-sentence investigation report to be prepared, provided to both counsel and court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to scoring the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing. Also, notice provided to probation. The defendant must appear in the courtroom at the time of sentencing. If there's any supporting documentation, must be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. It appears that in 19, the bond was canceled, and I'm not sure what the status of the bond was in 20. Ms. Weisenbach, your position on bond, please.
Ask the court to cancel bond in both cases.
Any objection, Mr. Rutkowski?
No, Your Honor.
Bond is hereby canceled, if it hasn't been already. All right. We'll see you then on the April 6th date. That will conclude the proceedings. Thank you.
Thank you, Your Honor.
All right, good morning once again, everybody. TCF Live on a hectic Monday, but that's what happens when we time change. So I've been on record in a couple of other places, and I'm going to go on record here again right now. This country of ours needs one time zone, FST, Freedom Standard Time, from East Coast to West Coast. I will allow for Freedom West for Alaska and Hawaii, but it's time to do away with all these shenanigans. Just my opinion. If you agree, write your congressman and tell them we need one time zone. Let's go to Michigan. We'll stay in Michigan, rather. Judge Elmore.
All right. Good morning. We are on the record today for the 28th Circuit Court here in Wexford County, and we are beginning today by taking up the case of People of the State of Michigan versus Brandon Michael Sias. This is file number 25-14000FH. Please.
Joanne Carey for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Sias.
Yep.
He's next to me at the table.
Thank you. Also here this morning is Mr. Kevin Stapleton. He is the agent from the Michigan Department of Corrections, who has prepared today's pre-sentence investigation report. The court has received a copy and gone over it. I didn't catch any need for correction myself. It's a relatively shorter report. And based upon a 10-year gap, there's not a lot of criminal history here to reference. So, Ms. Carey, any amendments, corrections, or objections to make to the comments for that report?
Don't have to the report. I do have a victim's statement that he wants me to read. He's not present, but he did provide one.
Of course, certainly. Mr. Harrison, anything to challenge regarding the report?
I don't think so, Your Honor.
All right, thank you. Ms. Carey, why don't you go ahead and read that statement provided by the victim?
His name is Charles Sampson. He He writes, I am at a loss for words still over a year later. The anger that comes with it is very difficult to control whenever I think about it. All the time and money I had put into my house that I owned, paid off, gone because of someone who had absolutely zero respect for someone else's belongings or livelihood. He had no financial loss for it, so why would he care? How will I ever be made whole again with the person when the person has nothing to begin with? I believe I should be made whole again. I have lost an unknown amount for missed rent. I have a $1,700 water bill, in part because of Brandon. I don't know what to think about sentencing other than how can someone have so little respect and complete disregard for someone's belongings and property. He did nothing to deserve it. I am out of a house and countless other things, and he is out nothing. He has a roof, 3 hots, and a cot this past year. If I didn't have people that cared, I wouldn't have had a roof over my head, even though I worked my butt off and owned a home. He also provided a receipt for $19,436 for plumbing services, but we are going to ask that restitution be held open because he's going to try to provide some more.
Thank you. Ms. Carrie, allocution then, since we're already over at your side.
Well, I can't say it usually much better than the victim said. He's very, this cost him a lot. Mr. CF, the defendant, did a lot of damage. He intentionally started this fire. He went next door and grabbed a gas can and took it back over to the residence and sprayed the gasoline inside and lit it on fire. That's very intentional. It did cause a lot of damage. There were other people in the home at the time who had to flee. But I understand the recommendation. I understand the sentencing guidelines and that he's been in jail now for quite some time.
So were there people in the building when he set it on fire?
Yes.
How come we don't have a scoring for number of victims if we had people that were placed in danger of injury or loss? I don't know, like how, like where were they sleeping? Were they?
Pretty sure there were. Very good question.
Yeah.
It should be scored.
I don't know why there's no scoring for offense variable number 9. And contemporaneous acts, but about the property damage. Right now, we have at least enough to score 5 points for OB16. There, how much money did you say it was worth? 18,000?
That's the a plumbing bill, 19,000.
Oh, what about the damage to the building?
We don't have any information on that yet. That's.
Was it destroyed?
Well,
it
it wasn't a total loss, is my understanding.
And our understanding is that that building had been condemned prior to the incident. Obviously, we'll flesh that out if we have to.
No. There should at least be 5 points scored for offense variable 16. Whether or not it was condemned, it could have been repaired. I don't know what the value of it was. Was it a residence? Wasn't it
It was a house.
a house?
Correct.
So did it at least have a value of $1,000 or more?
Would say yes.
Oh, there were people in it.
I can't find their names, although it's a known name. Stephen Petrovich and Abigail Southwick, I believe, were inside the house and had to run out.
Now, we had a couple very common names here in the courtroom, but sure. 2 of them. So you've got number of victims, 9. We're going to add 10 points to offense variable 9. And we're going to add 5 points to offense variable 16 to recognize the property damage. It's going to give us 15 points. It's not going to really do much of the guidelines. That's going to keep it the same. It's going to still be an intermediate sanction cell, but we want to cover this damage. That is on E-grid. So if we have those 15 points, that's going to give us an OB level 2. All right, and that's only going to change the range from 0 to 3 to 0 to 6. All right. And what we're doing there is we're acknowledging some of the damages in accordance to the points. But I'll tell you, if we see an arson sentence, can't imagine how nobody put in OB points. I don't know, but we needed to have that done. My suspicion here is because this case is kicked around for over a year, maybe it was just quickly done. But the value of the property, if it could have been more, then there could be more points. Now, I'm not going to say that that's going to change the guidelines much. In fact, it takes 9 more points even to move it from OB level 2 to OB level 3. And that would still only go up to a 0 to 9 month range, which is still an intermediate sanction cell. But my suspicion is that when we see when some are seeing an intermediate sanction cell, they stop and they don't go back through and do enough scoring. All right, thank you. Mr. Harrison, allocution.
Well, indeed, I think on one hand, it's pretty easy to look at this as pretty open and shut. It's a plea to an attempt, 3rd-degree arson. The guidelines are low. The jail credit far exceeds the county year that's called for in the recommendation. But I think it behooves me anyway to say a couple of things about Mr. Sias that I've gotten to know in over a year that he's been under my wing, so to speak, as a client. The court will recognize and remember, and so stop me if you've heard this one. This case had sort of a circuitous path because it found its way through the forensic center system. And there was an initial determination, if I remember correctly, that he was not competent, and that later changed, and it turned out that he was competent, and we were able to resolve the case. But it took a while to get him there, so it does appear to, at least to me, that part and parcel of what was going on that night was some kind of mental health crisis on his behalf. Even subsequent looking at the cases with him, now that he's in a much better, clearer thinking, relaxed state of mind, it's met with some degree of disbelief by Mr. Sias because he can't put himself back in the shoes of the person that did this ridiculously stupid and ridiculously destructive thing. I'm confident that he is currently getting the correct care, he's getting the correct medications, he's getting the correct insight into his own thoughts and actions that he will need to garner for the rest of his life, because this is not something that's going to go away. It's treatable, obviously. It's something that he can manage, obviously, but it's up to him to do it. I think this is an example of a court system and a mental health system that has done everything it can for the individual in question, and it's now time to kick him out of the nest and let him fly free. Can't say enough about the impact that just simply getting on the right medications seemed to have on Brandon and his thought process and the clarity of his presentation, et cetera, et cetera. So I'm very pleased about that, and so is he. He does enjoy the support of his family. Unfortunately, his father lives in Wyoming. And as mentioned in the PSI, his eventual plan is to go back to Colorado, but there's a great distance between Michigan and Colorado physically, and there's a great distance between his current situation and his old life psychologically. I'm confident he now has the ability and the tools to work through all of those issues and present a clear path for himself into the future. I don't believe this is the kind of behavior he's ever going to repeat again, because of the fact of the ordeal that he's been through, not just being in jail, etc., but the whole process of recovery here has been rather torturous. So I think it's a lesson well learned on a number of fronts. It took us a while to get here, but I think we're here. And I think this recommendation is appropriate under the circumstances. Thank you.
Thank you. Stiles, you have the right to make a statement if you choose. So is there anything you wish to say at this time?
Sir, I was surrounded by a bunch of demons at the time, and I was having trouble getting the devil off my back, and I had a panic attack, and I feel terrible for what I did. I needed help. I was at 125 pounds when I got in, and I'm at 175 now, and I feel much more healthier. I'm on the right meds now. I can think clearly. I'm not battling any demons anymore. I do plan on making it right with Mr. Charles. I do jewelry on the side and hope that I can come up with enough stuff to pay him off to make it right with him. There were people in the house at the time. I told them before it happened that I was about to try to start the wood stove on fire to get the house heated up, and it went bad. I decided to put gasoline on the trash piles before I put them in the wood burner instead of just putting the gas in the wood burner itself, and I ended up sparking a fire and got out of control. I apologize. I really do. I feel sorry for Mr. Charles, and I hope he forgives me.
All right, Mr. Stapleton, I need to ask you a question because we haven't, I don't think we've ever had this before. On criminal history, he got 217 days for an event that took place in the jail. How do I give him credit for that 217 days if that was his sentence? Because he was in jail on this case, committed an offense on February 21st of 2025. The conviction was in November. On the 12th, he got credit for time served. How do I give him credit for that time if he was serving a sentence?
I think you're correct. I don't think you would. I didn't catch that. It would, I think it'd be minus the 217 days.
Yep. All right. So we need to put a guideline, we need to change CFJ 145, page 2, deduct from the date range of February 21st of 2025 through November 12th of 2025. That will reduce it to 217 days down to 209 days. That he'll get credit for this, which will also change the credit on CFJ 145, page 1. Okay. So that still, however, is above the guideline range of the 0 to 6 months. All right. I somewhat here also at a loss because the description of the offense and everything we just talked about changed by the time I got to the defendant. The defendant statement basically tried to make it sound like an accident or a confused accident or something. I don't know. However, we're here today after the defendant entered a plea, was one of no contest. The court accepted it as such. This case at one time was a CSC, I'm sorry, not CSC, sorry, an arson second degree that would have put it on the B category. He would have faced there a 12 to 20 month potential sentence. However, that's not the chart that we're using based upon the plea. So to the victim in the case, that is somewhat a reduction. It went from 12 to 20 down to a 0 to 6. Court's hands are somewhat tied here because of the way the case has been resolved, and I'm not challenging the way it's been resolved. I'm just explaining it so in case that the victim is, ever goes to look at the review the sentence, review the court's explanation, that victim understands that the sentence today is based upon the pretrial agreement, and that it brought it down from a potential prison sentence down to an intermediate sanction cell. The court is not allowed to, the court is instructed by the law to begin with a presumption of probation, fines, and costs. However, court can take into consideration whether or not there are reasonable grounds for a period of confinement. Well, the defendant does have some prior criminal history, although it's relatively minimal. The defendant did, however, commit a criminal act while in the jail. Therefore, the court does have some reasonable grounds. Now, this is a long way to go about justifying the sentence. And yes, we are here in part because this case is kicked around due to competency and responsibility questions. So with all that said, I don't think probation is necessarily an issue here. The court sentences the defendant to 209 days with 209 days of credit, a $68 state minimum fee, $130 crime victims' right fund fee, a $300 court costs considering the length of time in which this case has been pushing in and out through the system. The court is not going to set a fine, again, no fine, an attorney fee of $300 to cover the expenses somewhat for the representation of counsel. Do we have any DNA fee here that I need to account for?
Yeah, $60 to the Wexford County Sheriff.
$60 DNA fee payable to the Wexford County Sheriff Department. There will not be any supervision fees, and then restitution will remain open for 30 days. To the victim, let's be realistic. Your likelihood of getting any restitution here is probably quite low. Definitely the amount that you're going to get over time, it's not going to reach the nearly $20,000. Find this sentence is reasonable and proportionate. Again, the anger felt by the victim is quite understandable. The law, however, ties the hands of the court to a certain degree, and my sentence is completely, I believe, within, well, technically it actually exceeds the guidelines, but I have to give him credit for the 209 days, so he's already served the most that I can really give him under the law. Miss anything, Mr. Stapleton?
I don't believe so, Your Honor.
Miss Carey?
No.
Harrison, any questions about the sentence?
I have none so far.
Mr. Science, Mr. Harrison is going to bring to you 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges that you have received the other copy. Now, this document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing filing an application for leave to appeal and not a claim of appeal by right. So if you wish to have the court appoint an attorney to assist you in appealing, which of course your sentence is done today, you can complete the bottom half and turn to the court within 42 days. Do you understand? So while this is a departure within the or outside of the guidelines, the court finds that departure is appropriate, because all I'm doing is really giving them credit for the time that is already served. All right. Thank you.
Thank you, Your Honor.
All right, once again, everybody, good morning. I hope you're all enjoying your Monday, if Mondays can be enjoyable, but we try to make them enjoyable here. This is why you come to TCF Live on a Monday, because, you know, you could do silly things like work, or you could just spend time with us. I'm just saying. Let's go down to Florida. It's time for Wade Mercer to do his first appearances, so let's make that happen.
Let's use one count of trespassing in occupied structure. Ms. Castaneda, there is probable cause in the complaint. I've also took a look at your criminal history, which looks great. I don't see any prior criminal history. I'm going to listen to the attorneys first, ma'am, and then I'll figure out bond or conditional release and so forth. Mr. Gill.
Yes, sir. Thank you. I believe the victim is in the courtroom today, Ms. Kennedy. I think she might want to address the court, but the state is requesting a bond in this case. In speaking with the victim, I think that Ms. Castaneda is homeless, and based on that, Your Honor, we're going to be asking for a bond.
Ma'am, do you want to be heard? Ms. Kennedy? You have to come on up so she can hear you, ma'am, and you can be on record. So if you'll come out up here, please. And Ms. Kennedy, what I'm going to do is just place you under oath and then be glad to listen to you. Okay, do you solemnly swear or affirm the testimony you're about to give in this case be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you. And you are Ms. Castaneda's grandmother? Is that what I read in the complaint?
Yes, I am.
And what is you want to say something about the case? It's a trespassing case. I did read the complaint. I know there was a trespassing warning, and allegedly she came back over there after being warned in November not to come back.
Yes,
Okay.
she did come back. We have housed her 3 different times in the past few years. She is homeless. She promises to cooperate, whether it is going into a mental health facility or going into a rehab facility type place like Stillwater's. She promises that she will cooperate, and then she does not. She either checks herself out of these places and becomes homeless again, or she doesn't cooperate. She destroys property and causes havoc within the facility, or she leaves the facility early. Now, we cannot continue where my husband has Alzheimer's. We are in our late 70s. We cannot continue to have Savannah pop in and out of our home. We love her very much. We wish the best for her, but she is homeless. She has no place to go.
Okay. What is Stillwater? I'm not familiar with that.
Stillwater's is a local rehab, a Christian rehab type facility. It's for
Local is in Jackson County?
local.
Female
It's-
Chrome.
It's
It's female
connected
Chrome.
with
Okay.
Chrome. It
I didn't
is
know it
a
was a
new Nora.
I didn't know it had a different name than Chrome. I'm very familiar with Chrome.
yes.
Okay. Go ahead, please.
So, there is a possibility if she wanted to do a major turnaround that she could go back to Stillwater's or a similar place, Lynn Haven in Louisiana.
Do you believe that the issue is mental health or some kind of drug abuse or a combination?
Well, last fall there was drug abuse because she I housed her for about 7 weeks. She insisted on getting Adderall, which she was prescribed by Appalachia Health Center, and Abilify. And she took the Adderall, and within a couple of days, she became combative. She became hard to handle. So I appealed to her to get off the Adderall and just take the Abilify, and she wouldn't do it. And that caused a situation that she went into mania and left our home.
Okay. Let me see if the attorneys have anything else they want to ask you. Mr. Gill, anything?
Do you have any concerns if she's released that she would come back to your property?
I have concerns that she will stay in touch with us. We've been the soft spot. And yes, I do have concerns that she will continue to be in touch with us. She loves us, we love her, and she always has the hope that we can do something, but we're to our end. We can't do anything.
So if
she's got to decide that she's going to get better and cooperate.
If she set a bond, are you asking for a condition of no contact at all? Or are you just asking for a condition for her not to come to your property physically?
I would rather have no contact.
At least for the time being.
Yes.
Okay. Mr. McDaniel, any questions for Ms. Kennedy? No, Your Honor. Thank you, ma'am.
Okay.
Thank you. Mr. Gill, anything else from the state?
Let me ask you one thing.
Sure.
I know that you and your family had talked with Stillwater yesterday and that she was supposed to go back over there. Are you wanting her, is that something you want her to do, is go ahead and go back to Stillwater?
I'd like to
Because
do that.
I don't see any, I don't see any drug issues. I see mental health issues, but I mean, I don't know if jail is going to be the right place for her. Is that something that you would like to have happen to her, go ahead and go to Stillwater?
Well, if it could happen, and if there was a condition that first of all, the director, Julie Jenkins, would have to know that she had a complete change of heart, complete, and that she would cooperate. She was destroying their property, saying, she didn't understand who did it, sort of thing. And, but she would have to convince them. Now, there is, I think Julie was leaning more toward her going to Lynn Haven, which is out of state, but it would put her out of the community where she couldn't just walk off and come to our homes.
Yeah.
But yes, I would like to see her in a rehab, but so far it would have to be the condition if she did not fully cooperate, she would go to jail. I think she would listen to that.
Anything else, Mr. McDaniel, with this witness?
I don't know if,
Anything else?
I don't have anything else for her, Your Honor.
Okay. Anything else in general? Thank you, ma'am. Mr. McDaniel.
I mean, Stillwater, I mean, it's a drug rehab. And they don't let them use mental health care because they have their specific reasons why, religious reasons why, is that, so I don't know if that's even the right place for her, and I don't know if jail's the right place for her either. I talked to her. She doesn't seem incompetent. She seems very much in her faculties. She left the facility and she had nowhere to go, and she, obviously thought that her grandmother would help her. And, I don't know what to say. I don't have anything else. We just asked for a cash bond or,
Ms. Daffin, the mother of the defendant, is in the courtroom.
I think your mother wants to say something, Ms. Castaneda, so come on up, Ms. Daffin. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth to help you guys?
Yes.
Go ahead, please.
So there have been drugs in the past. And I think that's part of why the mental health thing has come about.
Those drugs, were they marijuana?
Yeah, but you know how it's like kind of Molly-ish around here, like synthetic type stuff. So I'm not sure. I just saw a change in her mental health when she was at college. And I know there was a lot of drugs. I don't know all the drugs, but I know that there was a lot. But Stillwater's is supposed to be for any life controlling issue, including mental health. And I'm not certain. I think that a lot of what's going on here is like I know there's mental health, but I think it's also personality disorders type stuff. Like, like I'm gonna wreak havoc wherever I go. I'm gonna wreak havoc. And it might be for attention. I don't know what it's for, why she does it, but she literally can't live anywhere.
So there's what's called dual, there's mental health facilities, there's drug treatment facilities, there's dual diagnosis facilities, which are facilities that are specifically designed to address both. Mr. McDaniel's point is that Chrome is not a dual diagnosis facility. It is by far over here considered to be a drug treatment facility. So I think his point, I don't want to speak for him, but it sounds like she may need a mental health facility or a dual diagnosis facility, which are much more difficult to find.
Right.
So I don't know if we're going to be able to find anything today, but she's still entitled to a bond. Is there anything else you want to say? And I'm going to see if the attorneys have any questions for you.
If they can keep her long enough where like the medicine, where she can become lucid on the medicine. I'm torn about mental psych meds because she will not stay on them.
You understand she's got the right to a bond, and whether someone posts or not, it's a totally different question. But she has the right to have a bond set.
Okay.
Okay.
I just wanted to say those couple.
Thank you. Let me see if the attorneys have any questions for you, ma'am.
Nothing from the state.
Just to let her know that if they find a facility that they're comfortable with, they just let me know. But I do think it needs to be a mental health facility, not necessarily a drug facility. I think the issue is that because they don't want to give her medications. And that's what she needs more than likely. I'm not a doctor. It sounds like to me, you think that she needs medications and they're not big on giving people medications.
So, and here's the concern that I have. If the jail gets her on medication and she straightens out, we don't want to send her to a facility. The first thing they do is take her off the medication. That's a concern with drug treatment facilities.
There is a place in Kentucky called Hope City, and they do have psychologists there.
Okay.
But it is a rehab plus they do the medicines as well.
Sounds like a dual diagnosis then. Okay.
Yeah, they want you to get off your insurance and get on Medicaid in Kentucky.
Mr. Goodson's the county probation office supervisor. He's got hundreds of people get in, probably thousands of people get in programs, and he can talk to you more about that if y'all have a moment and you want to talk to him after court. He might have some ideas or some pointers. Okay. All right. So anything else from the state?
No, Your Honor.
Mr. McDaniel, anything else? State's opposed to cash bond, I take it?
Yes, Your Honor. Given the nature of the.
I don't think that's a bad idea. Just a second, Ms. Castaneda. Mr. McDaniel, anything else? I'm talking about that, Ms. Castaneda. I apologize.
Nothing else, Sean.
Ms. Castaneda, you wanted to say something before you say anything? I'm going to encourage you, don't talk about your charge, but something else you want to tell me about bond or release. I'm glad to listen.
Okay, it kind of is about both because I didn't really have a choice in what was going on. So I didn't feel safe at all. So I ended up just going to my grandma's house that night to stay the night outside and for her to hopefully take me somewhere in the morning or know any news. So I don't think I should be here. I've not done anything wrong illegally. And when I did, I'm not mentally ill. So that's not just something that you can imply on me. I'm fully aware and capable of understanding everything. So when my grandma gave me the choice to go to Stillwater's yesterday, and the police put me in the car, and he went back over there and talked to her, and he kind of talked her into putting me in jail instead. I didn't think that was fair. So I don't know. It's just not too fair for
Ms. Castaneda. If a officer gave you a trespass warning in November not to go on a property, and if you went back there in March, that's what you're accused of, that is a crime. So when you say you haven't done anything wrong, if those things are true and the state hasn't proved that, they just accused you of that, you need to understand if those things happen, that's a crime. Secondly, I'm going to set your bond. Your bond is $2,500 cash or surety. You have the right to a bond. I've never given a conditional release to a homeless person, and it sounds like you don't have anywhere to go right now, so conditional release is not an option.
Well,
your bond is $2,500. Let me finish, and then I'll see if you have any questions. Your bond is $2,500. You have a condition of no contact with the alleged victim. That means no contact with your grandparents at all. Now, obviously, they want to have contact at some point, but for the time being, no contact. If you post the bond, you're entitled to be released. If you don't post the bond, we'll see you on the upcoming docket, and we'll see if there are other options that the state and defense want to present to me. But for the time being, all I'm doing is setting your bond. It's really the only option I have. Now, do you have any questions?
Yeah, what's the other option? If you don't have, if it's really the only option, what, is there any other option?
There's no other option today. The options I have are set you a bond and give you a release. I can't give you a conditional release because you don't have a residence that can be verified.
I
The
know,
only
but
option I have today is
Stillwater
have an
said I could go back.
if someone from Stillwater was here saying that, that might be an option. That's not the case right now. The only option I have is to set you a bond, and that's what I've done. Do you have any questions?
Oh, no, sir.
All right. Have a good day, ma'am.
You too.
Yeah, let's give her notice for what day? March 30th, but she very well may be seen before then. Mr. Ricardo, good morning. I apologize. I didn't even see you on there. If you were there when we first connected, I apologize. You may have been there and I missed you, but we do have one interpreter case. And which case is that? Jorge Ramirez, I believe. Yes. So ladies, thank you for coming. Jorge Ramirez. I also got it in Washington County. They have him as Jorge Sanchez. So Mr. Ricardo, if you please introduce yourself to him and make sure he can see and hear us.
Muy buenos días, señor. Yo soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Nos ve y nos escucha?
Sí, está bien.
He can hear us and see us, Your Honor.
Great. Good morning, sir. You're here because you've been accused of one count of domestic violence battery.
Muy buenos días, señor. Usted está aquí porque tiene un cargo de agresión doméstica.
You also have a detainer from the United States Immigration Service.
También tiene una orden de retención de parte del Servicio de Inmigración de Estados Unidos.
Mr. Gill, I sent a text to Mr. McDaniel and Mr. Mitchell. I don't think you were on that text. I don't think you're on that text. I wonder where you were covering first appearance. If you please repeat that for him so he'll know about that communication with the attorney. I'll do it again. Mr. Gill, I sent a text this morning to the attorneys.
Señor Gill, esta mañana yo le envié una respuesta a los abogados.
Explaining that Mr. Ramirez has a battery charge on the same alleged victim that he got off probation of last year.
Explicándole que el señor Ramírez tiene un cargo de agresión contra la misma supuesta víctima con la que salió de libertad vigilada el año pasado.
But both his last name and her last name are different in that Washington County case.
Pero tanto el apellido de él como el apellido de ella son diferentes en el caso del condado Washington.
Because of the way the state attorneys, the way the officer set those cases up.
Debido a la forma como el agente puso los casos.
The Washington County case number is un momento, por favor. I know I sent a text. Mr. McDaniel, did I send y'all a text with the Washington County case number?
Yes.
Thought I did.
$25,572. That's the wrong one. $24,225
So 24225 is the Washington County case number with the different names, but it appears to be the same dates of birth.
It's the same. It's just.
Entonces el número de caso del condado Washington es el mismo, excepto que parece, o son las mismas personas, excepto que parece la misma fecha de nacimiento. Así es.
So, Mr. Sanchez Ramirez, I think you're entitled to a bond. I'm going to listen to the attorneys first.
Señor Sánchez Ramírez, yo pienso que usted tiene derecho a una fianza, pero primero voy a escuchar los abogados.
Mr. Gill.
We'd just be asking for a reasonable bond based on his history and that he have no contact with the alleged victim.
Señor Gill, solamente estamos pidiendo que le dé una fianza razonable y que él no tenga ningún contacto con la supuesta víctima.
Sí, está bien, muchas gracias.
Oh yeah, that's fine. Thank you very much.
Mr. McDaniel.
No, just a reasonable bond. He's going to go to ICE when he walks out that jail, so he ain't going to have no contact with her.
Solamente estoy pidiendo una fianza razonable, se lo va a llevar a inmigración, no va a salir de esa cárcel, así que no va a tener ningún contacto con ella.
Mr. Harrison, sorry, Mr. Sanchez Ramirez, it appears this case might qualify for a felony offense.
Señor Sánchez Ramírez, parece que este caso pudiera calificar para un caso de delito grave.
based upon you having a prior battery charge on the same person, your bond's going to be $5,000 cash or surety.
Debido a que usted tiene un cargo de agresión contra la misma supuesta víctima, su fianza van a ser $5,000 en efectivo o mediante un bono de seguridad.
You do have a condition of no contact with the alleged victim.
Usted tiene usted tiene la condición de ningún contacto con la supuesta víctima.
Just to say, I'll give you a chance to ask any questions in just a minute.
En solo un momento le voy a dar la oportunidad de hacer preguntas.
You need to understand just a minute. You need to understand that if you do post the bond, the United States Immigration Service has a detainer on you, so you will go into their custody.
Usted debe entender que si paga la fianza, el Servicio de Inmigración de Estados Unidos tiene una orden de retención contra usted, así que usted pasaría bajo la custodia de ellos.
Now, do you have any questions?
Ahora, ¿tiene alguna pregunta?
¿Cuándo puedo pagar la fianza? No sé.
So, when could I pay the bond? I don't know.
You can pay the bond immediately after first appearance if you wish.
Puede pagar la fianza inmediatamente después de la comparecencia inicial, si así lo desea.
If you do that, the United States Immigration Service will be notified that you're free to be picked up.
Si la paga, entonces se le notificaría a Inmigración que usted ya está disponible para que lo recojan.
And their policy is they will pick you up within 48 hours of you posting bond.
Y la política de ellos es recogerlo en un plazo de 48 horas después de que usted pague la fianza.
I'm going to ask the jail to give you a notice for your court date for March 31st at 9 a.m.
Le voy a pedir a la cárcel que le des la notificación de su próxima audiencia para el 31 de marzo a las 9 a.m.
Actually, that's going to be 9:30, Corporal, because it's a Spanish-speaking docket.
De hecho, Cabo, va a ser a las 9:30 porque estamos hablando de una lista de casos de los que hablan español.
Any other questions, Mr. Sanchez Ramirez?
¿Tiene alguna otra pregunta, señor Sánchez Ramírez?
O pues sí puedo salir aquí o para pagar la fianza si puedo salir aquí, no sé si qué día o no sé.
So, could I get out here? Could I pay a bond and get out? What day? I mean, I don't know.
If you post a bond, you will not be released. You will simply go from our custody to the United States Immigration Service. I cannot make it any clearer.
Si usted paga la fianza, no lo van a dejar salir. Sencillamente va a pasar de nuestra custodia a la custodia de inmigración. No se lo puedo dejar más claro.
Do you have any other questions?
¿Tiene alguna otra pregunta?
No, nomás.
No, that was it.
Have a good day, sir.
Que tenga
Campbell,
buen día.
make sure March 31st, Mr. Campbell, not March 30th.
And
Is that right?
Your
Give him the wrong
Your
day.
Honor, did he have a case number?
No, it was an arrest from this weekend. So he does not have a case number yet.
Okay, very well, Your Honor. May I be excused?
Yes, sir. Thank you, Mr. Ricardo.
Thank you, Your Honor.
So I'm not sure, the corporal stepped out. I'm not sure who's in the room out there, but we've got a sergeant or, hey, Sergeant, apparently I gave the wrong case number.
I was just making sure because
Oh, I thought I said the 30th.
you didn't say, you said the 31st.
So it's the 31st. We just to make sure that his written notice is the 31st. I'm not sure what I said.
You said that, but I just.
We got it.
Thank you. Thank you. We've had some people come in the courtroom, but they may be here for our pretrial docket. Does anybody else come in the courtroom for a first appearance case? No? Okay. So we'll go back to the next first appearance case, which would be Billy Harrison. Mr. Harrison, good morning. Mr. Harrison, you're here because you've been accused of one count of battery. Mr. Harrison, there is probable cause for the charge. Mr. Harrison, you also have a pending case you're out on bond on. That's a driving while license suspended. And that case number is 25572 CT. I'm going to appoint the public defender's office to represent you for first appearance purposes. I'm going to ask that you listen to the attorneys and we'll see where we go from here. Mr. Gill.
Judge, in this new case, we just asking for a reasonable bond that he not have any contact with the alleged victim, and we would ask that his bond be revoked in the case he's out on bond in.
Mr. McDaniel.
Your Honor, 25572 is a pro se case
Thank
that,
you. You're right.
and he's already pled out to that. I think he just needs to be sentenced on it, Your Honor. The battery case, which, you know, this is with Associate Allen. It is what it is. So, I mean, if y'all want to take her word on it. I'm saying that everything in that complaint is probably truth. That she probably stole from him. I'm not saying he did hit her, but, it is what it is, Your Honor. We just asked for a reasonable bond. And, you know, the citizen, he obviously has some health conditions. I've seen him out there. I know he's got some major health conditions. So he's got to be sentenced on the driving offense. So
I think Mr. Harrison has health conditions when he gets arrested, especially. Mr. Harrison, you can have a seat there if that's more comfortable for you. Mr. Harrison, I need to ask you about the driving license suspended charge. Go ahead and have a seat if you will. So when you were about to be sentenced on that case, you entered a plea. The state was asking for 90 days in jail. You claimed that you got that driving license suspended ticket while you were leaving the hospital.
Yes, sir.
So I set it for a sentencing date, and the purpose of that was to give you a chance to bring medical records in because Mr. Mitchell, the prosecutor at the time, was considering asking for a lower. Let me finish. Mr. Mitchell was asking when I asked for a lower sentence once you brought in the medical records. We set it for a sentencing like January 17th or 21st or something like that. But you missed that court date, and I later found out you missed it because you were in the hospital.
Yes,
so
sir.
That court date was never reset. So my question for you is, were you able to get medical records showing that you were leaving the hospital when you got the charge of driving while license suspended that you haven't been sentenced for yet? Did you get the medical records?
Yes,
Okay.
sir.
Do you have those with you at the jail?
They
Any chance you have them with you at the jail?
No, I know what I'm saying. I thought they had already been sent to you all, been brought to you all while I was in the hospital.
By who? Who was supposed to bring them?
My daughter.
Okay. Let me double check the court file to make sure they didn't go straight to the clerk's office, because if they did, the clerk's office would have scanned them into the file.
Yes, sir.
I don't believe they have. I think your daughter called and she brought some documentation to show that you were in the hospital on the court date, but she didn't bring any documentation to show that you had left the hospital when you got the ticket or got arrested for driving license suspended. So let's take a look at your file.
Yes, sir. I don't know what was going on. I don't have 3 seconds, sir.
There's nothing in the court file on the day you got the citation and arrested for driving license suspended. So I'm glad to set that for a sentencing. I think Mr. McDaniel's correct. He's not representing you in that case. You played without an attorney. We got to sentence you in that case. How long do you need? If I set the sentencing for tomorrow, can your daughter get those medical records up here for us to look at?
Sure.
Okay. What I'm going to do is I'm going to set that sentencing for tomorrow.
Say that, sir.
I'm going to set that sentencing for tomorrow. The one that you haven't been sentenced on, we're going to set it for tomorrow at first appearance at 8:30. And that's in case number 25572 CT. In the new case, it appears that may qualify for felony. He has multiple prior battery arrests. But they were like battery on a Leo. Let me finish, Mr. Harrison. Battery on different, they're enhanced batteries. So I'm not sure. And sometimes there's not dispositions on the court file. So the new arrest bond's going to be $5,000. Don't try to post it yet, because I'm going to hold you until tomorrow until we sentence you in the driving license suspended. You will get to use the phone in a few minutes to contact friends or family about getting those records up here.
I don't have the phone number, sir.
Let me finish. I'll be glad to let you talk, but you can't keep interrupting me. Tomorrow, I'm going to sentence you on the driving license suspended that you've already pled to. The state was asking for 90 days in jail before you claimed to have medical records coming from the doctor at the time you got stopped. So I'm going to sentence you for that tomorrow at 8:30. Now, you were trying to say something else. Go ahead, please.
Yes, sir. I don't know my daughter's phone number. I don't know about her. All I know
is her name Miss Masters?
Yes, sir.
All right. Good news for you. When she called about getting medical records for the court date, she left her phone number here. It's right here in the file. So I will text it to Sergeant Gross right now. So you will have her phone number. Any other questions?
Yes, sir. I need to know. That'd be all, sir.
All right. We'll see you tomorrow morning, sir.
Shit.
Sergeant Gross, I just sent that number from my judicial assistant Pamela put the number in the phone in the system when she called in last time. So I've sent that to you. Thank you. Next case is Joshua Bickham.
Good morning, Your Honor.
Mr. Bickham, good morning. Mr. Bickham, you're here for the charge of violation of county probation in case 25-83 ML. Mr. Bickham, I'm appointing the public defender's officer to represent you. Please listen to Mr. McDaniel, your attorney, and we'll see where we go from here.
Your Honor, I spoke to Mr. Bigum. He's going to enter a plea of no contest to the violation of county probation. He understands that the maximum sentence for this is 60 days in the county jail. He'll have 1 day jail credit, and there'll be restitution and fines that may be still owed in the case. He turned himself in yesterday. I know he's been talking to Mr. Tim about this case. About probation, and they worked out something to come in here today to turn himself in, and he just wants to address the court before we sentence, Your Honor.
You need Mr. Ham up here. Are you familiar with that, Mr. Goodson?
I mean, I got the records here. I don't.
He said they worked out something.
I don't know if they, I know there was some kind of conversations. I mean, it don't matter, and I told him it didn't matter what him and Tim worked out. He needed to say whatever to the court, not, so he's going to address the court.
Okay.
I don't know if it matters what they worked out or talked about.
Mr. Bickham, what I'm going to do is place you under oath, and then we'll see if this is what you want to do. Mr. Bickham, do you solemnly swear or affirm the testimony about to give in this case to be the truth, the whole truth, and nothing but truth to help you God?
Yes, sir.
Okay, Mr. Bickham, first of all, you got to understand you have the right to a violation of probation hearing. At that hearing, you would have attorney appointed to represent you, and the state would try to prove you violated your probation in a substantial way. Your attorney would argue you didn't, or that there are reasonable defenses to that. But if you enter this admission today, you're waiving that right. There will not be a VOP hearing. Do you understand that?
Correct.
You also understand the maximum sentence for this penalty, for this charge is 60 days in jail. I think the offer made to you this morning was 30 days. But do you understand the maximum I could sentence you to upon admission and listing both sides? If I wanted to give you the maximum, the most I could sentence you to was 60 days. Do you understand that?
Yes, sir.
And you want to admit you violated probation, but be given a chance to give an explanation. Is that right?
Yes. Yes, sir.
Okay. I'm going to accept your admission of violation of probation. I'm going to find it's freely and voluntarily entered with the advice of counsel. I'm going to look at what the allegations are. The allegations are that you were put on probation for retail theft on May 5th. That you reported, it appears maybe a month, maybe two, but that come July and August, we haven't heard or seen from you since. And to be more clear, that's May of 2025. So according to the affidavit, you disappeared in June of 2025.
I didn't.
And let me finish. And now 9 months later, we finally got you back in custody. I don't know how you got in custody. I'm glad to listen to anything you want to say. But before we do that, let me see if Mr. Goodson with the probation office has anything to add.
I'm looking at the records. He did report for May and June. We did not receive any written monthly reports after that. He did pay his court costs of $370 in full. He did pay the $129.22 restitution in full, and he did provide proof that he completed the retail theft program certificate. So he just quit reporting starting in July.
What about the affidavit also says there's $120 owed for something, cost supervision?
Yes, sir. He did have $120 arrearage on his COS, but he paid his fine in full, the restitution in full. He does have 120. He did pay 120 of COS, but 120 that was outstanding. We always put that on there as the balance. Technically,
that's if he would have been on the full 6 months.
Yes, sir.
And Judge, just for to let your court know, I guess first I heard this is that, I mean, we would have told him that after 3 months that, he got early termination. I can't help but wonder if he got everything done and he knew it was 3 months. And
well, he didn't do 3 months, so he did 2 months.
2 months, Stacy, or 3 months? You said he showed up for June.
He reported for May and June. He did not report starting in July.
When did he plea out? Was it April or?
Sir?
Did he plea out in May or?
Cut out May
He
5th.
put on May 5th, yes, sir.
So the 3 month period would have been June, July, August 5th. All right. So Mr. McDaniel, you want me to hear from him or hear from you?
Yeah, he's going to address
All right,
it. He
Mr.
did turn himself in, Your Honor, so just to let you know.
Thank you.
Yeah.
Thank you. Mr. Bickham, anything that you want to tell us? I'm glad to listen.
Yes, sir. Yes, I was put on probation. I'm not a resident of Florida. I was down here working and, I kept communication with my probation officer. I went back home to Louisiana. I had all the thing Mr. Tim told me to do is send out my paper. I did send out my paper. I checked in, I paid everything. I didn't know I had a warrant out for my arrest until I got stopped by a state trooper. And, he told me that I got a warrant from Jackson County. And he said, you might want to take care of that. So I called Mr. Tim. I'm like, man, I got a warrant. And he said, yes, you do, Mr. Bickham. And I said, well, how can I get this taken care of? He said, well, it's out of my hands. It got to go to a judge. So I was in Kentucky working. I had to leave my guys working. And I drove 16 hours to come take care of this, sir.
Probation violation. So why did you quit reporting? You haven't addressed that at all.
I thought after a 3-month period that I have to send no more papers. Like I'm back home. I wasn't in Florida no more. So that was my bad that I wasn't sending out papers.
Well, you didn't make it to the 3-month period according to the file. You only reported twice. You didn't even get to the halfway point before you stopped reporting.
The 3rd month I did send my paperwork off, sir. I did. I don't know if that's on file. I don't know if that's on file or not.
The probation officer, you've heard the probation officer say they never received that and they didn't hear from you.
Oh, wow. Well, that was a miscommunication, but I did talk to everybody. There was communication with everybody.
Okay. All right. Thank you, Mr. Bickham. Mr. Gill, anything from the state?
Nothing from the state, Judge. Defer to the court.
I'm taking a look at your criminal history, and here's what I'm showing. Very little in Florida, as you've already mentioned, but quite a bit in Louisiana.
Yes, sir.
These are charges. These aren't always convictions now, because sometimes they don't give us convictions out of state. Sometimes we don't get convictions in state. Simple battery in 02. Derisive, annoying words to another. Wow, that's a crime in Louisiana. You hear that, Mr. Gibson? Derisive, annoying words. You need to not go to Louisiana. You do that to me all the time.
So I'm a working man. As you can see the big gap, sir. I've been living right. As far as this petty theft, I don't even go to Walmart anymore, sir. I'm
gonna get to that. I'm just trying to get a better idea. Then there's another charge, 2003, the same thing. 2004, burglary of a dwelling. 2004, in possession, manufacture of Schedule 1 controlled substance, in possession of cocaine, and then 04, disturbing of peace. 07, second-degree battery, some kind of release on gain time, parole revoked. We're up to 09, domestic battery, hit and run, 09. Failed to comply with sentence in 2010 in Terrebonne, Louisiana. Unauthorized use of a movable, I'm not sure what that is, movable charge. Unauthorized use of a movable charge. It's a misdemeanor. Got about 3 of those charges in 2010, second degree battery. So it just kind of keeps going to 2013, aggravated second degree battery, 2014, domestic battery, 2017, second degree battery. You said there's going to be a gap in here somewhere?
Yes, sir. It was a gap. I think 17, that charge got dropped because they had the wrong person. But I haven't got in trouble since 13.
Was that 2019 driving while licensed intoxicated in St. Charles, Louisiana? That wasn't you?
Yeah, I caught a DWI. Yes, sir.
Yeah.
Yes, sir.
All right. So have you been to prison before?
Yes, sir.
How many times?
I've been like 3 times.
Okay.
But I
Thank you.
changed my life, and I'm a working man, sir. Like I try to stay out of harm's way. I'm kind of hurt. My family hurt right now because I promised my kids and my family that I won't come back to jail, and apparently I'm in jail. So we all hurting right now.
All right. I appreciate that. Appreciate you telling me everything you have. Anything else you want to say before I hear from the state?
No, sir. I'm just putting it in y'all hands now, sir. So,
Mr. Gill.
Judge, we just asked the court to consider his criminal history when this court imposes a sentence.
Yeah, I was not aware you had paid off your court costs and fines. That is something I consider. Mr. Goodson, you want to add something else? You were standing at the microphone. I didn't know if you had something else to add. No, it's okay. I want to sentence you to 20 days in jail. I think that's, you got probation. You quit reporting. I haven't heard a good reason why. I think you've kind of been a little less than accurate on your criminal history. And overall your criminal history is horrible. So I think 20 days in jail is a reasonable sentence under the circumstances. I'm going to give you credit for the time that you've already served. Mr. McDaniel, we have an idea, just 1 day. 1 day credit. Now, 20 days doesn't mean you'll actually do 20 days under Florida law. Mr. Bickham, you may do less than 20 days. You may do less than that because of Florida's game time law. So in 20 days, it's possible you'll do somewhere between 15 and 20 days. And whenever you finish that sentence, whatever that is, you'll be released. There's no probation left and you'll be through with this case. So we're just, I just don't think you're going to comply with probation. So we're going to just finish it up and be done with it. You wanted to say something, sir?
Yes, sir. Any additional fines? I don't mind paying it.
I don't add additional fines to individuals. I don't think I've ever done that. What I am going to do is what you have left, actually he has nothing left. So he has no fines or court costs left. That's good because that may help you get a little extra couple of days off your sentence because you don't have to spend time working off court costs and fines because you've already got them paid. No additional court costs and fines, you got them paid. And Mr. McDaniel's correcting me. It's not 1 day, it's actually 3 days credit. That's what the sergeant was going to say also. So it's 3 days credit on the 20-day sentence. You have at most 17 days left. Hopefully you're going to do less than that. And I wish you the best. Any questions, sir?
No, sir. Thank you.
Yes, sir. Appreciate you turning yourself in. That was a factor also.
Yeah, 16-hour drive.
Okay, friends. So he just mentioned the derisive, offensive, or annoying words statute in Louisiana. So I looked it up, and this is a thing. Louisiana Revised Statute 14103 defines disturbing the peace in part as addressing someone with offensive, derisive, or annoying words in a public place with the intent to offend or annoy. The annoy part is really interesting to me. Legal definition covers speech meant to provoke rather than specific listed derogatory words focusing on intent. The law prohibits using offensive, derisive, or annoying words in a public place. The intent, the speaker must have the intent to deride, offend, or annoy, or prevent someone from pursuing their lawful business. In context, these are often referred to as quote-unquote fighting words, which are not protected speech if they intend to incite an immediate breach of the peace. So, there you go. The more you know. We go to Louisiana all the time for the parole board, but I can't ever recall them bringing that one up. Oh, heavens. There is an embarrassment of riches this morning. I'm looking up at my big board, and I have easily 20 courts running right now. But let's do this. We haven't been here in a while. Let's go to Wisconsin. Judge Mogan, I believe she has a sentencing. Let's go there.
TCF 4-2, State of Wisconsin versus Stephanie Achterling. The state appears through District Attorney Kevin Schmidt in person. Ms. Achterling appears in person with counsel Shirlene Perrin. We're set here today in this matter for the sentencing portion of the case. The court did order a pre-sentence investigation report. The court has received that report. I have reviewed that report. The court also received an independent assessment from Independent Assessment Services, an alternate pre-sentence investigation report. The court has also reviewed that report. Victims' rights compliance.
We are.
Any victim's going to be making a statement?
Yes, Your Honor.
Okay, we'll get to that momentarily. Mr. Schmidt, have you received and reviewed both of the pre-sentence investigation reports?
I received it, I reviewed it, I have no corrections.
All right, Ms. Perrin, did you receive the PSI?
Yes.
From the DOC and any corrections or modifications for the record?
No.
Did you review it thoroughly with your client, Ms. Achterling?
Yes.
And she did not notice any corrections or any modifications for the record?
No.
She is currently in custody for the sentencing with you. We have one victim impact statement. I'm going to request that the victim please come forward and sit on the black, by the black table. You can either state your name for the record or you can state your initials, whatever you prefer.
My name is Mike McManus.
Can you spell McManus, please?
MC capital MANUS.
Thank you. You may begin.
First off, thank you for the opportunity to speak here. This is a case that's gone on quite a while. And I just feel like my property, my life, everything was violated. You came into my property, You took stuff that didn't belong to you and sold it for pennies on the dollar. You took sentimental things from me that I can't replace. You put a huge financial burden on me personally. You took a lot of things that were worth a lot of money. I had a outboard motor that I learned to operate a boat with. And to you, it was just an outboard motor. To me, it meant everything. My dad taught me how to use it, how to operate a boat safely. And you don't know this, but I spent the summer prior to that rebuilding that thing from the ground up. Brand new. And I was looking forward to using it the following summer. And I was notified that my stuff had been taken. I was a snowbird. I was in South Carolina at the time when you guys decided to take everything. And it hit me hard. And it really hit me hard when I got back up here for the summer. Damage to my camper, damage to my door, everything. I couldn't hire a moving company to do a better job than you guys did. You had to have made more than one trip, guaranteed. It just violated everything. And now I built a new house on that property, and it has a security system that I pay $45 a month for now. I never thought I'd need that here. This is the third time since my parents bought that property in '76. We've been burglarized twice prior, and I've also had theft from my vehicle on my property. I don't understand how it just keeps happening, and it's got to stop. I honestly believe that they need to be removed from our society for a little bit longer than what was presented, and I'll leave it at that. Thank you.
All right, thank you. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Thank you. My argument to the court is going to be that the court should follow the Department of Corrections recommendation, which is 5 years probation on the burglaries, 1 year probation on the thefts, withheld sentences on the thefts, state and imposed sentences on the burglaries of 4 in, 2 out, everything concurrent to each other. So from the PSI, we see that this is a person with no criminal history. She says she's been using methamphetamine from age 15 to present, which indicates she's one of those rare individuals we see occasionally come through the court where methamphetamine has not in and of itself caused criminal convictions while they were using it up until much later in their life. She went and did some college and reportedly did well in the PSI. She then worked consistently from ages 21 to 31. She became unemployed at age 31 during COVID and never went back to work. She was a dental implant technician. For the past 5 years, even from the PSI, it's been a real question what she's been doing to subsist and how she survived. With her training experience she had, it's kind of hard to believe she couldn't have started up work again once COVID was over. Her job wasn't like a restaurant job where a lot of positions went away permanently. I actually have a lot of cousins who do similar work that work stayed through COVID. Despite her saying she's been using methamphetamine for 21 years and drinking so much alcohol she blacks out, she questioned in the PSI whether treatment would benefit her. She says she might benefit instead from therapy. I suspect maybe what she's getting at there is she doesn't think she needs inpatient treatment, but would benefit from maybe something outpatient. That or she's talking about just therapy related to mental health. It's hard to say. At some point, this person started dating a man named Robert English. Robert English had a prior conviction involving receiving stolen property, where he was found with some burglarized property, and he said Kenneth Ochterling did a burglary and gave it to him. Kenneth said, no, I didn't. So Robert English got convicted of receiving stolen property. It was another case in roughly the same area. She says together, she and Robert English, I do appreciate in the pre-sentence investigation report, she talked about what they were doing, that they were just looking at nearby cabins, seeing which ones had the signs that this is snowbirds, this is people who aren't in their cabins all year long and picked those to burglarize. She admitted that Robert was out doing that, admitted she went out and did the burglaries with him. She says while she was doing this, she claims she was high on methamphetamine and blackout drunk on vodka. She did admit to having multiple victims in this case. As a result, she spent 339 days in jail so far, starting on April 4th to present. This is her first run-in with the criminal justice system. Her DNA was found at 3 of the scenes. Property from 4 of the burglaries was found in that room she shared with Robert English at his mother's house. All of the burglaries were local. They're all within a close proximity to that location. And this is consistent with what she told the PSI writer with how they were picking targets and what they were doing. I think DOC is correct in that I think she is a low risk to reoffend if and only if the following 3 conditions are met. And this is why I think they said probation. 1, and this is the most important one, no contact with Robert English. I don't think this happens, or at least she's not involved with this if she doesn't meet Robert English. 2, AODA conditions. She talks about how the methamphetamine use and the getting blackout drunk tied into this decision-making. No doubt it's tied into her decisions to associate with people like Robert English. 3rd, and this also I would say this might be even more important than the drug addiction one, given what she described with using since she was 15, work. She needs to get back to work. I don't think we can say it's a coincidence that she went to age 31 working, and then 5 years after that, she stops working. Well, 3 to 4 years after she stops working is when these happen, because these happened in 2024. I don't think that's a coincidence. I think if she's working and she isn't associating with people like Robert English and she's not using, this doesn't happen. We get people like Stephanie Ochterling occasionally on these PSIs, and it's always disappointing when we do. These people where they're educated, they have good work history, and then suddenly at some point in their 30s, they suddenly stop working, they stop associating with the social connections they had prior, and they just kind of break bad, they start using drugs, and they commit crimes. These are the people that have high rehabilitative potential. These stand in stark contrast to the cases we have where, we had somebody who is 40 or 50 and they have 5 years work experience at most to their name, where we know even if they weren't convicted during the time, we know how they were subsisting and how they were surviving. Stephanie Ochterling's obviously not one of those people. She has potential for being rehabilitated. So the way that ties in with how the court has to look at sentencing, it first has to look at probation, unless the probation would unduly depreciate the seriousness of the offense. If Miss Ochterling pled out on day 1 and came here and said, give me probation, it would have depreciated the seriousness of the offense. What makes it not do that here is that she has 339 days credit. She's been in jail for a whole year, and that's been front loaded in this case. That is why probation does not unduly depreciate the seriousness of the offense in this case, because it's not just 1 year probation, it's more than a year county jail if you count good time. What does get us to the state imposed prison sentence on this, though, is the gravity of the offense in this case. This is her first offense. This is her first conviction. Studies, when you look at recidivism, say the predictive factors for whether or not someone's likely to reoffend in the future, the 2 biggest things are your age and what your prior history is, and prior history is really in her favor. That's why Compass says low risk to reoffend. You don't need Compass to know that. In this case, however, you can look at it on the one hand and look at the time frame of where these happen and say this is one streak of behavior, it's one pattern of behavior, and look at it from that way and come to one sort of analysis. a way that I think you have to not depreciate the seriousness of it is more than that. It was multiple victims. And when you break down the behavior, I probably think about this more than, say, a judge might. When someone does a burglary, it's not just one discrete act. You can't just wave it away and say, I was on methamphetamine, I was blackout drunk, we went and did the burglary, that was bad, I'm sorry for that. Because it's more than that when you do a burglary. So doing a burglary necessarily requires a whole lot of complex decision-making and logic and actions over a long period of time. Because you need to make the decision you're going to do it. You need to find the targets that are soft that you could hit, pick a time to do it. You go and do it. Like Mr. McManus said, the nature of a lot of the property here, not just at his, but a lot of these, with the volume and the weight of some of the items, it would have took multiple trips or multiple people. So then you've taken the property. So then that part's done. After that is the part of, what do I do with it? Where do I put it? You have to necessarily think about those things. You have to think about, which things do we like? Do we keep? Which things are able to sell? How do you sell this sort of item? How do you sell that sort of item? Selling and getting money for these things can involve a lot of different contexts over a long period of time. What I'm trying to get at is, anytime you have a burglary, every single case, it also necessarily includes criminal thinking, because there has to be complex reasoning and logic in how you dispose of the property, how you pick it, all of the behaviors that go into the action. So that is something important too, as well as a condition of probation. I think every single burglary case needs one of those conditions for, like, the thinking for a change, moral recognition type treatment, something to deal with the cognition, because that problem exists in every single one of these. And it also shows why burglaries need to have, like, that state and imposed prison sentence here that DOC recommends. That 6-year, 4 in, 2 out sentence is important. I think with Stephanie Achterling, it's likely to be a pretty effective deterrent. This is a person who today is 36 years old. She just spent a year in jail. It's all the jail she's ever done in her life. And now the court's saying to her, if you do it again, or you do even something lesser that gets you revoked, you're looking at 4 years in prison. I think we know that with first-time offenders, people who are not frequent consumers of the criminal justice system, those kinds of deterrents are very effective. So I'd ask the court to follow that argument. I think it's the best way to make sure this doesn't happen again. I think with the year jail and with the state imposed prison sentence, the offense is not depreciated. I think the court has meted out the big sentence that was already necessary on the person who obviously masterminded this with Robert English when it did the prison sentence consecutive to his revoked receiving stolen property sentence. I think the 339 days she's already sat now and the state imposed prison sentence accomplish the same objectives here. Thank you.
Thank you. All right, Ms. Heron.
Thank you. We do have one person who wants to make a statement. That would be Pastor Goodwin.
Very briefly, you can come up here and provide a statement.
Thank you. I'll just read this. I'm Pastor Goodwin, Echdal Community Church in Grantsburg. And I wrote this letter to submit this, but the attorney asked me to read it. So this letter is regarding Stephanie Achterling, incarcerated at Burnett County Jail. And it's about my interaction with her. I have been meeting with her one-on-one weekly for the past 6 months. I've noticed a real sense of contrition and desire to make real changes in her life. I've had Bible study and prayer time with Stephanie each visit. She acknowledges that God's providence has her here because of her own actions and blames no one else. She has no church or religious background in her life, but has really responded to what the Lord has been teaching her through Bible study and religious services here in the county jail. And so I just give my opinion of her is the thought of her committing any of these crimes. Just she's come to be like a new person. She's very intelligent, and I would recommend that probation would be warranted. Thank you.
All right, thank you.
Your Honor, I have some certificates and another letter. Should I give them to the clerk?
You can just give them to me.
Okay.
Thank you. I've read the letter from Pastor Cecilia Pardon. All right, I have reviewed all of the certificates. There are many.
Thank you, Your Honor. Your Honor, the defense is recommending the recommendations from the alternative pre-sentence report, which is 3 years probation, a withheld sentence and 3 years probation on counts 2 and 11, 18 months probation, a withheld sentence on counts 2 and 35, all to run concurrent. The convictions, particularly on the burglaries, are on serious offenses. The defense generally agrees with the arguments of the state. I'm not going to repeat generally the statements made by Mr. Schmidt. I wanted to highlight some things about Ms. Achterling from both PSIs. I noted a few things that she kind of did in both PSIs. She talked about her childhood as being basically a happy childhood. Sounds like there were some challenges, but she characterized that childhood as happy. She spoke about some rough times in that relationship with Mr. English that included some abuse from him, some substance abuse. But interestingly, she didn't blame her behavior on anybody. I think that speaks to her ability to correct her behavior, as Mr. Schmidt alluded to in his argument. So I would ask the court to consideration. She recognized the harm that she has done. She understands what and has come to understand more and more throughout time that she has spent in custody, the harm that has been done to the victims. And one of the things that could also be done during a term of probation is some kind of community service, in addition to other things like therapy. It would seem that also based on the pre-sentence investigation and the alternative report, that there is some level, I'm not a therapist, but also it seems like there's a theme of kind of codependency in her life, first with her brother, then with Mr. English. And again, she is not blaming them on her, she's not blaming them for her behavior. But there does seem to be a pattern in her life, and she's choosing people to be around with. But that may also assist her in the future, for her to stand up more for herself, for her to have the self-esteem to continue with her education and to be more successful in her life. Because of her lack of prior history, because of her prior success in life, her lack of blame of others, her acknowledgement of the seriousness of what she's done, her potential for correcting her behavior. We do ask the court to withhold sentence and place her on probation. I understand the state's perspective on the imposed and stayed sentence. However, there are also reasons for the court to withhold sentence and have some measure of an ability to impose a sentence when the time comes if there is a revocation. I'm optimistic that Ms. Achterling would not be in that situation based on getting to know her over the last year. I can't imagine that would happen. I'm very optimistic for her and hope the court will adopt one of the recommendations here today. And I believe she has a statement she wants to make.
All right. Ms. Achterling, if you're going to read a statement, please make sure that you can read it slowly and enunciate your words so that both myself as well as my court reporter can hear and understand, okay?
Okay. Your Honor, thank you for allowing me the opportunity to speak today. I know how it feels to lose something that cannot be replaced. And I know that knowing that I caused the same hurt to another person and their family and how it affected them and their family deeply breaks my heart. Nobody deserves to go through that kind of pain. I understand that saying I'm sorry doesn't make up for the peace and security the victims once had. My actions were unexcusable, and I deeply and truly apologize from the depths of my heart. Before coming in here, I was going down a destructive path, and being brought in here has saved my life and forever changed my life. While being in here, I've attended all the groups that were offered to me, which has given me the tools necessary for a better future. Because of the situation, it brought me to God and to accept Jesus Christ as my Lord and Savior, who has given me a new positive and healthy outlook on how I want to live my life. With that being said, I want to thank you for saving my life. I plan on finding a church in my community if given the opportunity to return home. I want to continue on the right path with God on my side and following the guidelines and help given by probation. And I'll continue to maintain my sobriety through finding support groups in my community. I also want to get stable employment and continue to improve my life. I'm committed to following all the court requirements. Your Honor, I respectfully ask the court to consider my efforts to take responsibility in the changes I've made and will continue to make while determining my sentence. Thank you for taking the time to listen. Thank you.
Ms. Achterling, I have heard the arguments of both attorneys. I've heard a character reference for you. I've read a letter. I've seen all of the certificates. I've read the Department of Corrections pre-sentence investigation. I've read the alternate pre-sentence investigation. I've heard a statement from the victim. I have read within the PSI document other statements from victims of lives that you have impacted. There's a lot here. There's a lot for the court to sift through and to look at. When a court sentences an individual, I have to look at multiple factors and multiple things. First, I have to look at the nature and the gravity of the offense, or the offenses. Here, there's multiple. And that's the seriousness. How serious are these matters in these cases? Second, I have to look at your character, your prior criminal record, all of those things that are contained in both of these documents. And then I have to look at the need to protect the public. I have to look at other things as well. I have to look at the effect of the victims, any rehabilitative needs that you have. If there's any, undesirable behavior patterns, your culpability, your age, your education, your history. I also have to look at what's called deterrence. There's two types. One is specific deterrence, to specifically deter you from committing other crimes, or especially crimes like this, and general deterrence, to generally deter others from doing the same thing. All right. And when I'm looking at deterrence, specifically with you, a sentence has to be crafted to ensure that, again, this is serious enough that you understand that you cannot engage in things like this. You have to change your habits, the things you do. You have to change your associates, the people you hang out with, Robert English, perhaps even your brother. You have to change yourself. All right. That's the only way you can significantly improve your life and stay on the right path. You have to surround yourself with people who have the same alignment of any desired goals or any other positives, people that can greatly influence you in a positive way and not in the negative, how it's happened the last few years. All right. With general deterrence, I have to look at generally deterring others from, again, doing the same or similar crimes. We live in Burnett County. I live in Burnett County. You do not. A lot of the people in this room live in Burnett County or have a vacation residence. There are so many vacation homes in Burnett County. You're from Minnesota. You have no connection to Burnett County except for Robert English and his mother and her home here. That's your only connection. And you're shaking your head up and down because that's true.
Yes.
Okay. But Burnett County, it's a small county. In the winter time, in the colder months, other than having snowmobilers and those things and ice fishermen, when we have nice weather to do so, nice snow, we have a population of about 18,000, 19,000 people, okay? In the summer, when we have all of the people who come and have all of their vacation homes, because we have many, many vacation homes, our population skyrockets, okay? We can go up to 80,000 or more people in this small county during the warm months. That makes all of those vacation properties, all of those homes with snowbirds and people that go away for the winter, vulnerable. And it has. We've had multiple strings of burglaries. And as it's been stated in Mr. English's sentencing, he was part of a crew or himself that engaged in multiple burglaries over multiple times and years. And now you, since meeting Mr. English, joined forces and you burglarized multiple homes in Burnett County, homes, and by homes, I mean vacation properties, cabins, those kinds of things, multiple places and some multiple times for one place. And that is victimizing an entire community. That is putting an entire community in fear. Because when you burglarize somebody's home or somebody's vacation property, their cabin, etc., you're not just taking away from them property. It's more than just personal property. It's more than the fishing gear. It's more than the ATVs, the UTVs. It's more than the motors. It's more than, you know, the tools and all of those things. What you are taking away from people is their peace of mind. You are taking away their security. You are taking away from some people their home away from their home, their place that they come to decompress, to de-stress, to enjoy life, and to get out and to enjoy what Burnett County has to offer. And the more that we have individuals like yourself and like Mr. English and like your brother coming in and destroying that, the more you are destroying Burnett County's ability to have tourism, to increase their ability to support each of the people that reside here in Burnett County and make this home. So your impact of burglarizing one property or two properties or three properties or one more than another, you are impacting more than just 3, 4, 5, 6 families. It's an entire community. Burglaries are serious in multiple ways, including the fact that I know that it sounds, from what I've read and from what I've heard, that each of the homes or vacation properties were either staked out or cased, so to speak, to see if and when people have been there so that they're an easier target to hit. But the fact is, that it's this crime, it can be defined as serious also because even though you staked them out, you cased the joints, you did the things and thought that people were not going to be there, when you hit that property, when you went to go take things that weren't yours from that property, somebody could have been there. Something more serious could have happened. We could have had somebody hurt or killed had you not known that someone was unexpectedly at their own property. And we could have been here for a far more serious crime in addition to these crimes. Now, I've reviewed and read all of the information and all of the facts and about you. Other than starting to use substances at a very early age, and it sounds like, I'm not sure if I gathered this correctly, but your brother may have been an influence. That's what I've read or gathered from these documents. But it seems like, other than that, you had a pretty good childhood. You have a mother who's been protecting you and being there for you for your whole life. And you're kind of shaking your head up and down. And you didn't have some of the traumas that I see of other people sitting in that chair. But for the fact that you perhaps had some issues and you decided to use substances and alcohol at a very early age. I don't see the reason as to coming down this path or finding Robert English. Because all in all, I've heard really good things said by the district attorney that up until the age of 31 or so, you were doing well, you had good jobs, you did things, you were a good daughter, you had all of the positives. You lost your job, that happens, but usually people then go, okay, I'm going to gather everything up. I'm going to look at a different career. I'm going to do some other education classes, or I'm going to get their certificate, and I'm going to do this instead of that. But instead, you allowed negative associates in your life and people to kind of help change your path. They were your choices. Wasn't a mistake. You made the choices to associate with individuals that you probably at the time knew you shouldn't. And you continued down that path because with each and every casing of a property, with each and every staking out that property to see if it was a good target, with each and every break of a window or jimmying of a door, or with every time you cut off a padlock or whatever you did to get into these properties, each and every time it was a choice and you knew it was happening. And then each and every time you came back with your loot, your treasures from other people's properties, you sifted through them like they were just found or abandoned property, and you took what you wanted and you decided what to sell and how to sell it and who to help sell it, and you brought other people involved. You had other people involved in this, or other people were. But each and every step was a choice. You could have walked away, you could have said no, you could have told authorities, you could have told your mom, you could have told somebody else. You could have done anything at each of the specific dates and times and steps that could have prevented further loss from other people. But you didn't do that. You waited until you got caught. And there was a huge investigation. I'm going to tell you, just because we're a small county doesn't mean that we have officers that don't know how to do their jobs. They do, and they do very well. Because this wasn't an easy thing to pinpoint and to track and to find and to determine. So I need to look at protecting the public, and that means I need to protect the public from you and from behavior like this. I need to also protect the victims that are involved, because they have specifically been targeted and are suffering and impacted by your decisions. So I have to look at that. But the state is correct in the fact that the law requires that I look at probation first. Probation is the first thing I have to look at. Unless confinement, that means prison here, unless prison is necessary to protect the public from further criminal activity from you, unless you need correctional treatment. That means you can only get the treatment confined in prison because you're not going to be able to do it on your own. You won't seek the services. You won't listen to an agent. You won't do those things. Or if probation would unduly depreciate the seriousness of the offenses, okay? When I'm looking at this case, it's very serious. They are serious. And it's aggravated because we have multiple burglaries, multiple victims here. But in looking at the things that I have to consider, and the fact that you have no criminal history, You were law abiding, except for using substances and doing those things. And or you may have engaged in other things, you just didn't get caught, but you were law abiding until you were 31 or so. You have the ability to become law abiding again. You obviously have brains, or you wouldn't have had a good job like you did. So you can do something else. You just have to steer yourself that way. And you have to be dedicated enough to want you. You have to want you and want a better life for you. You choose you next time. Don't choose someone who's giving you flattery here or there or trying to make you feel good. That's all talk. Only you can make yourself feel good. So if that means going to therapy, if that means getting a better job by doing education, if that means getting certificates, that's what you have to do, because only you can make you feel good and only you can allow yourself to love yourself. Based on the totality of the circumstances, I'm going to craft my sentence this way. And there's going to be the necessary protections for the public in general, as well as for the victims specifically. With regards to, I'm going to go with the thefts first. I believe that is count 26 and 35. With the misdemeanor thefts, what I'm going to do is I'm sentencing you to 9 months of jail. As a sentence. And I am assessing $443 in fines and fees. With regards to the burglary counts, I am sentencing you to three and a half years of initial incarceration with 3 years of extended supervision. But I'm staying that and placing you on probation for 5 years. This is a blessing for you. You could have been sent to prison today. With the burglaries, what I'm going to do is I am going to order that there be 1 year of conditional jail with credit for the time she has already been serving. So that would mean, I believe if I've calculated it correctly, because I think the jail goes by 360 for a year. You do go by 365 for a year?
12 months is 360 and a year is 365.
Oh, okay. Thank you. So then I had 21 days, but that is not correct because I was going by what I thought was correct. So you would have about another month to serve because this is serious and you need to understand the severity. And with regards to the theft and the conditional jail, they are concurrent, the same credit. We have 339 days of jail credit. Conditions on probation and extended supervision. No contact with Robert English. No contact with Kenneth Achterling unless your department or your DOC agent approves. An AODA assessment and follow through. no use or possession of any illegal drugs, substances, or paraphernalia, no alcohol, no bars, taverns, liquor stores, casinos, or establishments that have the primary purpose for the sale or the service of alcohol. If you are employed at a place that serves alcohol, you must get your Department of Corrections agent's approval for that employment. You must have gainful employment or additional education. Regular testing. And so you know that the no use or possession of illegal substances, that does include THC. Even though you're living in Minnesota, you may not use THC, even for medicinal purposes. No contact with Burnett County except for probationary purposes or court-related purposes. Any court-related purposes. Or any other purposes that you've asked the court for a written permission to do so, and you must have court approval. The court believes here that based upon the number of vacation homes and the fact that there is proven staking out or scoping the homes where people were snowbirds or they were not using that property all the time, that the community is at risk at whole for further burglaries. You may not have contact with Robert English's mother or obviously her home. No contact with any of the victims, their residents, or any vacation properties that they have. $15 hours of community service per year for the first 3 years of probation. Any program that your agent deems necessary. No contact with any convicted felons unless in a treatment facility or your agent's approval. You must reside with your mother until your agent approves otherwise. With the felonies, $518 in fines and fees. You are paying probation because there is restitution. Is the restitution stipulated? What is that amount?
Bringing up the supplement submitted to the court real quick.
I have
Lindsay,
24
Lindsay, real quick, thank you for the gifting of the 10 memberships. I very much appreciate that.
filed on May 2nd, 2025. There's a later one, earlier.
There's an October 1st one. It's document 41 and 25 CF42. I picked the right one. And that is
$2,344.84. The court is ordering stipulation or is ordering restitution per the stipulation, and that is joint and severally liable with co-defendants. They're going to, again, pay probation. The court is going to order $500 per month in payments. The payments will begin, I'll give you a grace period because you have another month of conditional jail, and you're going to need to get out and try and look for employment. It will begin August 1st. That is a condition of your probation. If you fail to make your payments, you fail to abide by your conditions of probation, then you could be revoked and you could be sent to prison. It's very important. If you don't have the ability to pay $500 per month, the court is going to have a restitution hearing restitution hearing. You'll come to restitution court and you will advise the court as to why you are unable to pay that amount per month. And there could be consequences, which could be additional conditional jail and or revocation. If you are revoked off of probation, you would be eligible for substance abuse programming, earned release programs, and the challenge incarceration program. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Failing to pay your fines and fees, not only will the court enter a civil judgment against you, but you could, the court will issue a warrant. You could sit up to 6 months in jail because you are still on probation. That would be extraditable from Minnesota to Wisconsin. I need your DNA. The jail will make sure that they get your DNA. In a case like this, I'm not certain if you'd be able to have it expunged from the system through a written letter to the Department of Justice. I don't think this is a felony that you could do that, but you certainly can try. So you would need to do a written letter to the Wisconsin Department of Justice, not to this court. 339 days of jail credit. May no longer use or possess a firearm for life. No voting in any election until your civil rights are restored. Mr. Schmidt, what am I missing?
The only request I'd make is for the no contact with Robert English's mother. If we put that by name, Diana Bellinger, just because I think she's going to be going to a jurisdiction other than here where they might not know who that is.
Thank you. So that is very important to have. Diana Bellinger, mother of Robert English. And that means any residence that she has. So if she moves to Minnesota, you still can't see her in Minnesota. Anything further?
No.
Ms. Perrin.
The only thing I would note for the record is she may not know the names of the victims. She may not know their addresses and other locations. I'm just noting that for the record.
Go in her records so she would be able to have those.
Okay.
I believe. Because Department of Corrections will be able to provide that to her and let her know who she cannot have contact with. I don't think they'll they won't give her their addresses specifically, but perhaps they might say Edina.
Okay.
Anything further?
No.
All right. Then you have additional conditional jail to sit. Once you are done with that, you're going to need to make sure that you have your probation set up here, and then they'll transfer it to Minnesota. Again, you are required in order to live with your mother until Department of Corrections otherwise determines appropriate, okay? All right, then we are adjourned. Thank you.
Thank you.
TCF Live, it's a Monday. It's good to have you all here. Lots of new people, I think, out there based on the stats that I'm seeing. So if you are new here, feel free to say hi in the chat. This is an incredibly friendly community. You've stumbled into a good place. Note for the fourth hour, The first half an hour of the fourth hour, we're going to do court. The last half, I do have a couple of things I want to cover, so we'll get into those. Let's do this. Let's go to Texas per our promise. Well, we still can. 9 to 11% more, Judge Boyd.
So the motion for speedy trial for dismissal, before we go on the record, so I can be clear about everything, it is for 2024 CR 008124.
Well, actually, Judge, all the cases are basically the same transaction, so it's going to apply to all of them. I'm sure I found it in all the cases.
All right, could I see it for all cases, please? Let me check this. Motion to dismiss it? Yes. And is it there for all cases? Yeah.
I don't see it for.
All right, court is calling, and you've had a chance to review.
I have, Judge.
All right, court is calling 2024 CR 008124, 2024 CR 008173, and 2025 CR 007834, State versus Christian Alan Ruiz Garcia. Could I have parties announced for the record for the state?
Brandon Prada for the state.
Defense.
Raymond Martinez.
And are you Mr. Christian Alan Ruiz Garcia?
Yes, Your Honor.
All right. Defense has filed a motion in each of these cause numbers to dismiss for lack of due diligence and violations of right to speedy trial. All right, defense, it's your motion.
And Judge, I would ask the court to allow me to basically make this argument in all these cases. They're all one series of events that all happen together, so.
Any
It
objection?
wouldn't be. any
None from the state.
All right, you may proceed, counsel.
But Judge, the court will recall, and I'll also bring up that one of the reasons for today's setting was to bring the defendant, who was a juvenile, who's now in TDC, to court because we want him to testify in our case. We can't even accomplish that because nobody has his birth date. I don't have access to his birth date. The state, and I'm assuming Norma was never able to
All right, and
obtain that information.
the court will note for the record that defense counsel did file applications for a bench warrant. All right, you may proceed.
And so, Judge, this case happened in June of 2024. Specifically, well, I thought I had the specific date, but I don't, but the court has it before it. It's in June of 2024, Judge. The defendant in this case has demanded his right to a speedy trial when we filed our notice of appearance back on June the 11th of 2024. The cases got indicted on August the 8th of 24. So he's been under indictment well over a year and a half. In terms of the harm issue, Judge, I'm just going to go through what I've recited in my motion. The critical witness, Joshua Garcia, who was a juvenile at the time, a co-defendant, I think everybody can agree that he's in essence a co-defendant, was charged in juvenile court.
And just one moment, state, do you agree that's co-defendant?
It is, Judge.
All right, you may proceed.
And that his cases were adjudicated in the juvenile court. And then so much time has passed, Judge, he actually has been released from juveniles and since it was a certification, he was then sent to TDC, which we believe he's there. We haven't actually found him. And today we were set for purposes of seeing whether or not he responded or that he was presented to the court pursuant to our bench warrant. In this case, Judge, if you recall, the defense has been asking us from the very beginning, because he's a co-defendant and because he has his own set of discovery, and more importantly, in this case, he had other aggravated robberies in addition to the ones that were with my client. So our theory was, it wasn't our theory, our defense is that my client was participating in the particular case he was involved in under duress. And we wanted to be able to demonstrate in the trial of this case, the character and the nature of this co-defendant, what he had done in the past, his use of weapons, his MO, if you will, to show that because my client was only involved in this particular date and he wasn't involved in the others, to help support our suggestion that he was operating under under duress. But we can't get any of that evidence. If the court will recall, more than a year ago, this court had a hearing where the court asked the juvenile prosecutors to appear and to answer to why they wouldn't give us this evidence. And they in fact appeared on Zoom. And this court had the opportunity to question them and find out.
And they said they would not be giving the evidence.
They refused.
Yes.
One of the few times I've seen a lawyer in this court actually tell the judge, no, judge, we refuse to do what you're telling us to do. Okay, so we stepped back from that and we regrouped. We found a provision in the code that says that we can petition the juvenile judge to have a hearing and to determine whether or not circumstances exist where he would order the disclosure of the records. So we did that. He denied it. They argued against it. He denied it, except to the extent that he said we could review the file that pertained to our case. Well, that was kind of pointless. We already have the file that pertains to our case because we have discovery from my client. But we'll give it a go. Never got them. We provided case numbers to the state. The state said we don't have those files. And to further clarify the record, the juvenile prosecutors told us that they, in essence, took into consideration the cases that my client is charged with and never really pursued them because he had so many others that he got prosecuted on. So they weren't even sure where those cases were in the system. Not sure they even got filed on.
And when you say other cases, you're speaking about your client's co-defendant.
Correct.
All right.
The co-defendant had double-digit number of aggravated robberies. And so the ones they chose to prosecute didn't coincide with my client's case, unfortunately. So that was another area in which we were not able to get the records. So we said, well, let's get the defendant here. Let's get the co-defendant here. Maybe we can get through him what we need, but we can't get him here. And I will tell you, Judge, that Abe Garza, and I think we've talked about this before, and I think he's been here before, is the juvenile's attorney. And he has suggested to me, and as an officer of court, I will tell you that his advice to this client is going to be not to say anything, which is understandable because those cases weren't prosecuted. They still could be, theoretically. And he could expose himself to all kinds of problems, not only with those cases, but with perjury and everything else. So even if we were able to get him here, I don't believe we would have been very fruitful.
All right.
But,
and the court will note for the record that in regards to discovery, the request by the defense for discovery has been well over a year. The juvenile prosecutors did zoom in and no one had any objections to the prosecutors zooming in. And they informed the court that they would not comply with discovery. And so state, here's my question. With regards to juvenile, if it is information that is exculpatory, basically what I'm being told is you don't get it because it's a juvenile. They won't even give him the date of birth of the witness in order to have the witnesses appear by bench warrant. So, and that ship has sailed with regards to bench warranting him here because this has been over a year. So that's what my understanding is from juvenile prosecutors, and their understanding of the law is that even if it is exculpatory, his client is not entitled to it because the other person is a juvenile.
And Judge, that's as confusing to me as it is to everyone else here. Under 3914, if it's relevant, then it is to be given to the defense. I don't know. My knowledge of juvenile law is rudimentary at best. My argument would be that any discovery that would come from the co-defendant would also be, all this stems from the same incident. So all of the discovery, be it for the co-defendant or for the defendant standing here, would be exactly the same because it all stems from the same incident.
But I mean, do we really know that? Because he hasn't been given access to it, and defense is entitled to exculpatory evidence. And I will say that the prosecutors in this court, you all are not the prosecutors who denied this defense the discovery that they needed. However, you all are all working for the district attorney's office. So everybody's responsible for discovery.
Judge, sorry if I could just chime in here, but I think like the distinction.
If you could announce.
Yes, it's Megan Galloway for the record. The distinction in this case is that there's a legal reason why it's not being provided. I believe under the family code, it's protected because the defendant the co-defendant was a juvenile at the time. And so we've certainly exhausted our resources. I understand that the state is a state and we are working together. However, the divisions are walled off from each other, so we don't have access to that information. So I want the record to be clear about that. I am not in possession of those materials. And then albeit whatever the juvenile prosecutor did come in here and say, the petition to the juvenile court was still made, and that court determined that it should not be turned over. And so at this point,
and I know that the prosecutors in this court did all they could to get the information to defense. Is that correct? The attorneys in this
court, of course, Judge,
Yes.
and I don't dispute anything that counsel just suggested to the court, but that could have been avoided. When they went to prosecute that juvenile, all they had to do was call the prosecutor in the 187, say, hey, we're getting ready to go forward on this guy. This is our deal. We're going to work out. Let's discuss what you're doing with your case. Maybe they would have made mine go forward first. I mean, there's so many ways it could have been avoided.
Well, I mean, I know there are different ways it could have been avoided, but I'm just going to deal with the facts that's being presented before me. And I want the record to be clear that the prosecutors in this courtroom did all they could to obtain the information that you were requesting.
I'm not disputing that, Judge.
And what I will say again, it appears that prosecutors in other courts, whether it's juvenile or not, people think that the law means that if there's exculpatory information, if it's a juvenile, too bad, so sad for your client. And the defense can't even get to the point of his defense of perhaps duress because he's not being given access to the information. And this has been going on for over a year. But I just want the record to be clear that the prosecutors in this court, I don't think, I know that you all did all you could to obtain the information.
then Judge, just to address one thing, the date of birth of the co-defendant was provided in the discovery that we received. So
Okay. He should have that.
has
Okay.
that.
All right. And I understand what you all are saying about the bench warrant with that. But we're still at a point where this court thinks under the law, the defense is entitled to exculpatory information, whether the person is a juvenile or in the juvenile system or not, because then what are we really doing? He can't present his defense, and nobody knows, for the record, nobody knows if it's exculpatory or inculpatory because he's not being given it. And obviously based upon what the defense is presenting to the court, that their defense is or will be, he's saying as an officer of the court that he believes the documentation would show that potentially.
It would help us to prove that point, we think, Judge.
Yeah. So is there anything else from either side?
Judge, I just understand that. I understand what the court has explained. I just don't believe that dismissal is a proper remedy in this case. And so I don't know if the court would be able to reach out to Judge Shaw, because I mean, that was his ruling. So at this point, my hands are tied because that was his ruling under the family code.
Mhm.
And I would agree that neither party knows what is in those records that are over there. However, if we're getting to the point of, or their argument of duress, there are pieces of evidence where, in this case, that were turned over, like statements from the defendant that do address that if they would like to put it forward.
All righty. Is there anything else from either side?
I think our position is pretty clear, Judge.
All right, just give me 5 minutes and I'll give you my ruling. Thank you.
Your Honor.
All right. Arlene Gay, you're here?
Yes, Your Honor.
Kevin Williams?
All right, well, I'll circle back around when she has her ruling. Let's go to Judge Stevens, say good morning to him.
24 CR 1699 is called the State of Texas versus Michael Sam. You're Mr. Sam.
Yes.
And you're here with Mr. Dusler. Is that your final answer? To
Yes,
Don, you got the plea papers? She didn't have none.
I did them.
There's a hold up on that.
Trying to fire up the tablet when else are closed. I get it.
Probably the tablet's fault.
No, it's my fault.
It's always been the tablet up to now.
I'll take blame this time.
All right, in 24 CR 1699, Mr. Sam, can the court proceed in summary?
Yes.
You were here with Mr. Dusler, you were attorney, the state's attorney. In summary, my goodness. We got a page full of facts here.
Yes, sir.
You don't want to be called a thief,
No, sir.
but I've got 10 prior theft convictions here.
So,
Sir, that was in the old days?
yes, sir. This one wrote to like this. My mom.
I don't think 2022 was in the old days.
Nah, that one would.
And then you got this one now in 24. All right. In summary, paragraph 1 alleges that on or about May 12th, 2024 in Jefferson County, Texas, you committed the offense of theft. And paragraph 2 goes on to allege that you have 2 or more theft convictions out of district and county courts at law. And once you have 2 or more theft convictions in county courts of law or district courts, if you steal a pack of gum, it's a felon from here on. And actually, you've been a subject to felonies looks like since 2008. So it's time. That's a lot of time. For 15 years. So you were looking at a state jail felony, which carries with it no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can also be assessed. Give me my. There it is. Do you understand what you are charged with and the punishment range that's applicable in this case?
Yes, sir.
Agreement has been reached where you would be pleading guilty, sentenced to 14 months in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this case, sir? Guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will?
Yes, sir.
And because you are guilty?
Yes, sir.
I'm going to show you here what's marked as State's Exhibit 1. Did you sign this document, understand it, discuss it with your attorney, or the contents all true and correct? You are mentally competent to enter your guilty plea. It's freely and voluntarily. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Let me ask you on paragraph 2, which are these prior convictions of thefts. The last 2 allege that on or about January 24th, 2019, out of the 412th District Court of Brazoria County, in cause number 84434, you were convicted of the offense of theft. And the next allegation, which is the last one of all the priors, alleges that on September 9th, 2022, which would be over 3.5 years later, in the 461st District Court of Brazoria County, you were convicted of theft in cause number 95842. Is all of that true and correct as it is alleged?
Yes, sir.
And are you pleading true and correct to those allegations voluntarily and because they are true?
Yes, sir.
All right. Not a good sign when you're starting off using whiteout on the first case. That's not good luck in Haiti, from what I read.
No.
If nothing further, I'm going to find you are pleading guilty to paragraph 1, alleging theft on or about 2024, May 12, 2024. You are pleading true to allegations, the last 2 allegations of convictions in the 412th and 461st District Courts of Brazoria County, Texas, in 2019 and 2022, respectively. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of the jail felony in paragraphs 1 and those 2 prior convictions in paragraph 2. I now find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You are hereby sentenced to confinement in the state jail for 14 months. You will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
What are you doing about this now? It's a long time. It's time you became an honest man.
Yes, sir.
Okay. Good luck.
Thank you.
Do it. Make your choices.
All right, let's head back over to Judge Boyd.
Just 1 second. All right, we're back on the record in 2024 CR 008124 and 2004 CR 008173 and 2025 CR 007834 State versus Christian Alan Ruiz Garcia. Just for the record, the court will note that discovery issues have been ongoing in this case since, at least according to the court's docket, since October 31st, 2024. And with regard to the defense's motion to dismiss, and each of the cause numbers, the court will grant the defense's motion to dismiss for want of speedy trial. It will be based upon the defense's inability to proceed with trial due to the lack of discovery. Is there anything else?
There you are.
All right. Thank you.
Thank you, Judge.
Thank you,
Excused.
And counsel.
And now we know how that finished up. Let's go back to Huron County where we were earlier today. New contestant there.
3 files, 257333, 257348, 257349, time for sentencing in all those matters. As stated, Mr. Osentowski is present, represented by Attorney Michael Borowski. People are represented by Prosecuting Attorney Timothy J. Rukowski. By way of history, a no contest plea to assault by strangulation and child abuse force was entered on November 13, 2025 at 7333. Defendant also pled on that same day to aggravated stalking in 3348 and in 7349. No contest pleas were entered. A no contest plea, that is, was entered to obstruction of justice, again, on November 13, 2025. A pre-sentence report has been prepared by Ms. Karen Everland. It's dated, December 17, 2025. Mr. Borowski, have you and your client had the opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
No, Your Honor.
Any objections scoring the guidelines?
No objection.
Mr. Osentowski, do you agree with both of those answers?
Yes, Your Honor.
Want to make sure. You've read the report as well?
Yes, sir.
And you don't have any corrections, correct?
No,
Or the guidelines, correct?
sir.
Okay. Mr. Rakowski, any objection to the report as well as guidelines?
No, Your Honor.
Thank you. Mr. Borowski, what would you like to say on behalf of your client before the court imposes sentence?
Thank you, Your Honor. Mr. Ostowski doesn't shy away from his criminal history. He does have a criminal history and he acknowledges that. He's had the chance to reflect on his actions. You know, on that day, he never set out to put his daughter in harm. You know, he loves her very much. You know, he wants to be a positive role model for her. He wants to be a part of his daughter's life. Mr. Ostowski does have a ton of family support. We have read the recommendation. Your Honor, we would ask that the court sends Mr. Ostowski to the guideline minimum in file number 2530733FH. We ask that the court sends Mr. Ostowski to a guideline minimum of 21 months, Your Honor. In the other files, the guideline range is 14 to 29 months. We ask that Mr. Ostowski be sentenced to the minimum guidelines. In the alternative, Your Honor, we also ask that Mr. Ostowski be considered for the SIA program. Mr. Ostowski was going through therapy, has been working on his mental health. You know, for those reasons, Your Honor, we'd ask for this type of sentence. Thank you.
You're welcome. No contest pleas were entered by Mr. Ostowski. Does he wish to address the court, Mr. Ostowski?
Your Honor, in light of no contest please, Mr. Ostowski will not be giving an allocution here today.
Very well. Thank you. Mr. Rakowski, on behalf of the people.
Victim's rights case, Your Honor. I believe the victim wishes to address the court.
Please. First, to the young lady in blue, your name, please.
Ashlyn Akentowski.
What would you like to tell the court, Ms. Ostowski?
I'm here speaking on behalf of my daughter, a victim in this case. She is the victim of her father's abuse, and the trauma he caused did not end when this case began. It follows her every day. She lives with fear, anxiety, and emotional pain caused by repeated harm from the person who is supposed to support her. The effects of repeated trauma are visible. She struggles with emotional regulation, fear, and instability. She carries stress that no child should have to carry. The long-term consequences are deeply concerning, as repeated exposure increases the risk of lasting psychological harm, difficulty forming healthy relationships, and ongoing emotional distress. This was not a single mistake. This is a pattern. It demonstrates a lack of accountability and disregard for the safety and well-being of others, especially his own child. Each time he chooses violence, substance abuse, and unlawful behavior, he deepens her trauma and reinforces the message that she is not safe. The damage from repeated abuse is lasting, and no child should have to carry that burden. He sends a damaging message to a child who is still learning right from wrong and trying to understand the world around her. There's also a deep shame and confusion for a child growing up with a parent who repeatedly breaks the law and continues to appear before this court without change. He has never followed the rules. He has never taken responsibility. Prior court involvement has not stopped him. His continued choices have caused instability, forcing us to live in fear rather than allowing my daughter the secure and peaceful childhood she deserves. As her mother, I live in constant fear that I will not be able to protect her or myself if he is released. The fear is based on the repeated history of a person who believes he can operate outside of the law and face no consequences. I'm asking this court to impose a longer sentence. Shorter sentences and second chances have not worked. A longer sentence is necessary to protect my daughter, to give her the stability she needs to heal, and to finally hold him accountable for the harm he continues to cause. My daughter deserves safety, she deserves peace, and she deserves a future free of fear.
Thank you. The young lady with the black top, would you please state your name?
It's Heather Ingalls.
Spell your last name, please.
INGLES.
Ms. Ingles, you may proceed.
In every instance of domestic violence, the person chooses to commit abusive acts, knowing that they are wrong based on his or her belief and moral system, when they can and should choose not to. Many people think of domestic violence and they think of physical abuse, but the truth is domestic violence isn't always simply visible to the eye. Domestic violence is anything that is done to gain power or control over an intimate partner, including manipulation and threats. Even in this statement, I don't feel that I can fully explain the mental and emotional impact this has had on me. It is almost impossible to describe how overwhelming it is to even think about. How can somebody make you feel so loved and so worthless at the same time? It scares me how close I came to just being another name, another statistic, another woman's life who was stolen by a man who thought that he had the right to take it. I thought the worst was enduring it, but it wasn't until the pain started to fade that I understood how much I had been living with, how much I had endured beyond his charges. The grip that he had on me didn't end when he was arrested. It lives inside of me, wrapped around my mind like chains that I couldn't see, convincing me that maybe somehow it wasn't as bad as I remembered. That maybe I had overreacted, maybe I was a problem, maybe if I had just done things differently that he wouldn't have hurt me. But that's what trauma bonds do. They twist and desensitize reality until you don't even trust your own mind. They make you crave the very person who's destroying you because the abuse isn't constant. It's a cycle. Pain, guilt, apologies, and then brief moments of loving kindness, just enough to keep you hooked. Just enough to make you believe that somewhere inside of him is a man that you thought you fell in love with. Once I escaped, I thought that I had survived, but survival isn't just making it through the near-death moments. It's everything that comes after. Part of me knew that he was poison. The other part still searched for the version of him that I had wanted to be real. And that's what people don't understand about surviving abuse. It's not just about leaving. It's about unlearning. And it was strangulation less than murder. I will never be the same person that I was before I met him. He took something from me that I can't get back, which is my peace, my security, my belief that the people that you love will protect you and not destroy you. I asked this court not to give him another slap on the wrist and let him do this to someone else, more so his daughter. He didn't just lose control one night. He didn't just snap in a single moment. He makes continuous choices and chooses control, isolation, assault, humiliation, intimidation, manipulation, and violence. He chooses still to this day, incarcerated, to terrorize those that love him, leaving a permanent scar on mine and his own child's heart. He chooses rage. This man has already been given too many chances. He's already shown you who he is and continues to be, even locked up. He has violated the no contact and PTO over 20 times and is still continuously 8 months and 2 jails later doing so. He has proven that court orders, legal consequences, and jail time will not stop him. He acts as if he is above the law. He doesn't care about the rules or the value of others' lives. He doesn't care about the damage that he does and continues to inflict on me, his ex-wife, our children, and our families. He only cares about control through coercion and a diminishing false narrative. But for all of us, his victims, unfortunately, his reign of abuse and destruction is and has been very real, extremely brutal, physically horrific, emotionally terrorizing, an assault that was nearly fatal. I asked the court to finally do their duty of justice in protecting and serving his victims who simply tried to love him and have already suffered and continue to be terrorized by him to this day. I asked for justice, protection, and peace.
Thank you. Mr. Rakowski, you have the field.
Your Honor, we ask you to take into account the victims that have spoken here today. Mr. Osadowski comes before you with 1 prior felony, 7 prior misdemeanors. And I think what's the highlight of it is as the one victim had indicated, the pattern of abuse of constantly control, violence, and then there's just enough kindness to hook a person back in. That has been his pattern. That has been his pattern with the last case we had with his ex-wife. That's his pattern in this case. That's the pattern in the case that we had in district court before. Stalking, whoever he doesn't like. And that's what we see out of Mr. Rosenthal. He's a very dangerous person. We understand that the guidelines are what they are, and he needs to be sentenced. We would ask the court to consider the sentence that is recommended by the Department of Corrections, because I believe that is the maximum end of the guidelines in this matter and for the top charge, and we ask you to consider that.
Counsel.
While we wait for them, a quick reminder tonight, In the Blind with Mike and Dan, 7 p.m. Eastern, 4 p.m. Pacific. That is a show that has me and Michael Groff, our sometimes guest host, our all-time sidebar panelist, and the guy who does the Phoenix weather discussion. So I'm sure Barb will drop a link for that in the chat here at some point, but please do join us over there tonight. New show, lots of fun.
The court spoke with counsel sidebar because the guideline range in the last two files, the aggravated stalking, obstruction of justice, guideline range is 14 to 29 months. However, the recommendation is above that. And I just wanted to understand what was going on with it. So that's the guideline range relative to the aggravated stalking, obstruction of justice, which means that the court can go to the low end of 14, which was requested by Mr. Borowski, up to the high of 29 months, up to 5 years. In the 7333 file, that guideline range is 24 to 50. So I want to place that all on the record as well. Mr. Rakowski, is that a fair assessment of our conversation?
It is, Your Honor.
Mr. Morosky?
Yes, Your Honor.
All right, thank you. I had the opportunity regarding Mr. Osentoski to overhear the preliminary examination of this matter. And the court is aware of the circumstances regarding these files. And it's clearly reflected in the pre-sentence report. They have a young individual come before the court, and I say young, age 37, with one prior felony. Up until things really started falling apart, successful business person, doing everything he needs to do, a family, eventually, because we are a small circuit, this court handles not only criminal proceedings, but also family-related matters, divorce proceedings. And it just appears to the court that once the divorce was going through, things were just starting to fall apart. And a fall from grace, essentially. A sharp-looking individual with a bright future, and then all of a sudden the wheels fall off. The prior felony conviction, the court knows. And the court knows as well that the defendant, I believe, was originally on probation regarding this matter. In that file, when these offenses occurred, and I failed to ask this, Ross, is there any objection to one pre-sentence investigation report covering all files?
No objection, Your Honor.
All right. And so you put all that together on the night in question, the defendant had tested with a PBT of 0.141. There were claims of making statements of drowning his daughter, whom I've seen in the past loved his daughter. No question about that. Is it the alcohol? Is it the buprenorphine? Because the defendant took that as well. Was it substance use to turn this around? I don't know. And there were other violations of the no contact order. to the extent that we have victims appear in court and appear to be scared to death of this individual. That's what they state. And when you mount it all together here at the end of the day, Mr. Ossentowski, easy for the court to say, you have to let it go. These relationships, whether they're controlling, whatever the situation may be, you have to take a step back. Look out for the best interest of your child or children. But at the end of the day, the controlling behavior has to stop. And it's going to stop. It will be the sentence of this court in 7333 that the defendant be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of 4 years to 10 years, credit for 86 days served. That's within the guideline range. He's to pay a crime victim's assessment of $130. Attorney fees are waived. Court will assess cost of $200 in this file only. $68 in state costs will be ordered. To count 3, child abuse 4th degree, same file, 365 days in the county jail, credit for 86 days previously served. $50 in state costs will be ordered. In 7348, aggravated stalking will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of 29 months to a maximum of 5 years, credit for 29 days served, again within the guideline range. Crime victims assessment of $130 will be ordered. Attorney fees are waived. $68 in state costs will be ordered. Finally, 7349 will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission and placed in their custody for a period of 29 months to a maximum of 5 years, credit for 29 days served. Crime $80 in state costs will be ordered. No court costs will be issued in all the other files. And my understanding is that these sentences run concurrently with each other and concurrent with the previous sentences. That's correct.
Yeah, no consecutive.
All right, so that's what the court will order. It's my duty to inform the defendant he has right to seek leave to appeal in this matter. If he's financially unable to provide counsel of his own choice, the court will assign counsel for the public expense. He's to initially receive the questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Yes.
I apologize. Attorney fees and 349 were waived as well.
All attorney fees are waived.
Thank you.
You're welcome. Court is in receipt of the notice of right to appellate review and request for appointment of attorney form. What is the status of case number 257347FH? That's marked as a miscellaneous hearing.
Your Honor, it's my understanding that case would be now revised.
Trukowski?
That was my understanding, Your Honor.
Upon receipt of the order of proposed order of Valley Process, court will execute. Anything further on that file?
No, Your Honor.
Mr. Trukowski?
No, Your Honor.
That'll conclude the proceedings. Good luck to you, Mr. Ossentowski. Off the record.
All right, folks, let's go back to Texas and Judge Stevens again.
All right, we've got 2 cases. What are we going to do? What's up?
We're gonna put it through to counts 1, 2, and 3.
In each case?
In each case, then we're gonna ask that an updated PSI, there's a half of 12 months state jail.
A whole bunch of misdemeanors, Jeff.
Just misdemeanors.
All right, 21-36529 and 36760 are both called. The state of Texas versus Averiana LaDelia Beverly. Did I get that right?
Yes, sir.
That's you, with your attorney, Mr. Burbank, and the state's attorney. There are 2 first amended motions to revoke unadjudicated probation filed in January 28th. Does the defendant waive formal readings of these, and can we proceed in silence?
She does, and you may, Your Honor.
And does the defendant waive any additional time that she may have from the filing of these motions to proceed today?
We waive in each case.
Hold on. Ma'am, please raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lord. In summary, 36529 states that on May 3rd, 2022, in this court, you were placed on 5 years deferred or unadjudicated probation for burglary of a building, a state jail felony. Is that all true and correct?
Yes.
And in 36760, this alleges that also on May 3rd, 2022, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of theft. Is all of that true and correct? Which ones?
1, 2, and 3.
Allegation 1 in each case states that on or about August 5th, 2025, in Jefferson County, Texas, you committed the offense of unlawful carrying of a weapon in violation of your deferred or unadjudicated probations in each of these cases. Is that true and correct?
Yes.
Number 2 states you committed the offense of illegal possession of a controlled substance on or about August 5th, 2025 in Jefferson County, Texas. And is that true and correct as it is alleged?
Yes, sir.
Doesn't say what the
Methamphetamine.
methamphetamine, was it methamphetamine? You don't know?
That's one of many, Judge.
Just one of them. There
It was a cocktail of a group of it. Okay, including methamphetamine.
Yes, sir.
3.
Same thing, just same.
Okay.
Same day.
Okay.
We can just do 1 and 2. It's fine, Judge. If she's taking the plea.
Let's just do 1 and 2 because they're worded the same way, but it's stating illegal possession of drugs, but it's not describing what the drugs are in each case. They're word for word the same. So are you pleading true then to allegations 1 and 2
Yes.
of each of these first admitted motions to revoke unadjudicated probation voluntarily and because those allegations are indeed true as they are alleged?
Yes.
Do you understand that a knowingly and voluntarily made true pleas in 1 or more cases, that is enough to grant a motion to revoke probation? Your probations could be revoked. You can now be found guilty and sentenced to no less than 180 days up to 2 years in the state jail. Knowing that, you insist on pleading true to that. I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true in each case.
Hey, I'm working on it. Right.
The agreements in each of these cases are whatever sentence shall not exceed a cap of 12 months or 1 year in the state jail in each case. And these cases would run concurrently. Is that your understanding of the plan?
Yes, sir.
If I follow these agreements, you have no right of appeal of your case. Do you understand?
Yes.
Words can't describe it. What you have to do to erase something, which
That's the good old days when you just turn the pen upside down, erase it like an eraser.
nope.
think he's totally screwed up the food package.
Oh, no, there it is. Whoever buys this, I think they come from another country and they're working to overthrow this country. That's because there's just no way this is practical. And again, if I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
What we're going to do in each of these cases is do a pre-sentence report.
Yes, sir.
And we'll come back and each party will be able to add additional information for the court to consider. And then the court will make its ruling. Then, do you understand, man?
Yes.
How long have you been in jail, man?
I think I'm going to hurt this. Very interesting. Sure. No. It's not even 10 o'clock in the morning.
They don't get to stop. Hopefully it's there to fill in time before you correct by forward. Another thing, I'm gonna show you what's marked.
It's marked.
It's marked in each case as States Exhibit number 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true and correct? States Exhibit 1 is tendered into evidence in each of these cases. Without objection, it's admitted. This also states if I follow these agreements, you will have no right of appeal of your cases. Do you understand?
Yes, sir.
All right, we're going to reset this. We'll see you back here in how much time do you think?
4 weeks.
It's 4 weeks good?
Yes.
Okay, thank you.
Let me excuse to that.
Yes.
So this has nothing to do with court, but I'm going to share it anyways. So I just got a text. This is a courtesy text from the city. This is a notice of intent to increase water and wastewater rates. Questions? Email us. Sometimes I don't want these pieces of communication anymore. I don't want a smartphone. I don't want text. I just want to be left alone. Anywho, I don't know. Government costs. It's all out of control. That having been said, let's go to somebody who has things in control. We'll move across the hall, Judge West.
Now,
In cause number 26, DCCR 0096, you're charged with the first-degree felony offense of aggravated robbery from October 23rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I've been working on it, but it's a court appointment. So
Right.
I haven't heard anything.
So when you're in custody, we give you a court-appointed attorney automatically. But if you make bond, then I expect you to at least try to hire your own lawyer.
So I'm working on it. I'm talking to Charles Roloff.
Okay. So what I'm going to do is reset your case for about 30 days or so. That'll give you some time to try to get someone hired. If you get someone hired before that next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the people you've talked to so I know you're trying, and then we'll discuss your options. And if you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, if you step in front of the clerk, she'll give you your reset notice. Daryl Albritton. Good morning, you're Daryl Albritton.
Yes, ma'am.
And Mr. Albritton, did you get someone hired?
Right at the moment, I'm working on getting a new job. They ain't paying me enough. You know, I got bills and I'm paying child support.
Where are you working?
It's, they ain't giving me no per diem. So I'm, gonna go offshore. I'll be able to do it. I've been talking to people, so.
You've been coming here for a long time,
Oh,
right?
I'm gonna have somebody this time, though. I'm talking to a guy named Darryl Ward.
Who'd you talk to this last time?
Ruthie, Whitney Jones, and Todd Ashley.
Speak up, I'm sorry.
Rudy, Whitney Jones, and Todd Ashley.
Where are those
They
located?
in Beaumont.
Not a single one of those are criminal defense attorneys here in Beaumont
But they attorney, they lawyer.
that handle criminal cases.
Yeah,
What'd they tell you that they would charge you?
well, you got 35 up front,
Who?
3,500. But some you know, they don't do payment plan, but I found out Darryl Ward, he do payment plans. I
Daryl
found out about-
Ward?
Yeah, I found out about him by dude like Thibodeau out there.
I don't know any of the names you're saying. I've been here for 30 years. So what are your hours? How about how many hours a week do you get?
Sometimes we get like 40 hours a week, or
At how much an hour?
that's like 22. But you know, I got child support and I got all that shit.
But you've been, I'm looking back now and I don't know how we've let this go as long as we have. You've had plenty of time to save up. Even if you saved $20 a week, you could have been where you needed to be.
You know,
So you got to make this a priority.
yes, ma'am.
I need someone hired before the next court date. This is your final reset. I know you have bills and child support and things like that, but you got a good job, you've got to get some money and save it and get someone hired before that next court date. You understand? Step in front of the clerk. Brissa de Hoyos. Good morning. Are you Brissa de Hoyos? And Ms. de Hoyos, did you get someone hired?
No, ma'am, but I did want to get a court appointed.
Okay. Did you talk to some lawyers like I asked you to?
Yes, and it's some like other, it just broke.
You didn't write it down or?
So it was in my notes, and my other.
Okay. Are you working?
No, ma'am.
Why not?
I'm looking for a job right now.
Are you? Where are you looking?
I was gonna go back to fast food. I do hair though.
Okay. Well, if you were going to go back to fast food, when were you going to do that?
As soon as I get hired.
Have you been making applications?
Been to a couple of interviews.
But what?
I haven't been getting any calls back.
How old are you?
19.
I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, and then I'll take a look at it. Step in front of the clerk and she'll give you that paperwork. John Gray. Good morning, sir. You're John Gray. And Mr. Gray, this is, I'll say you've been here before. Did you get someone hired?
No, but I am selling my house. We're closing in 60 days. I already got a contract on it. Paperwork. That I can do self-representation.
Well, that's typically not advisable. Did you bring any paperwork to show that your house is under contract by
Not
chance?
in my phone. I've got the contract. Actually signed it. It's signed. Day, when, too long ago, last week, I think.
Are you working?
Yeah, I'm self-employed.
Doing what?
Self-employed.
Doing what?
State federal labor laws. Hopefully.
Okay. That's what you're here for and in trouble for, right?
Yes, but no.
Well, here, okay, let's start with this. First of all, as a condition of your bond, I am ordering you not to attempt to sell or go into any business and hold yourself out to work for the Department of Labor or anything. Listen to what I'm saying. You cannot sell any poster or anything that has to do with employment, labor law, anything like that to a business while you're on my bond. Do you understand?
Okay.
You need to go get a job working for someone.
Yeah.
Okay. And so that you can afford an attorney. If you can get one when you sell your house, great. But I'm resetting the case 30 days. When you come back, I want you to either have a job or show me where you have attempted to get a job, and filled out applications or whatever it is. And again, if you are caught continuing to sell or attempt to sell any type of poster or paraphernalia or anything at all, there's no loopholes in what I'm telling you. You cannot do what you've been doing. Do you understand? If you do, your bond will be raised for violating that court order and you'll be back in jail. Do you understand?
Yes.
All right, step in front of the clerk for your reset.
We close 60 days on the.
You're getting a 30-day reset. I want you to do what I asked you to
Yeah.
do between now and then.
So that's super interesting. I'm going to try and track this down. So he's selling posters for like labor laws and stuff, and somehow that got him into trouble. Curious.
Mr. Guillory, did you get someone hired?
Oh, no, I just recently lost my job. I just got another one.
Where are you working
I
now?
was gonna have some.
Okay. Where were you working?
I was looking at the Golden Pass, Sabine Pass.
Okay. So, but when do you start with this new job?
I started it Thursday of last week.
You already did?
This one.
Okay. So did you talk to some lawyers? Do you know who you're going to try to hire?
I've been talking to some, but I left the paper that I had at home. I don't know.
Why would you have left it at home when that was one of the only things I asked? Everybody's, it's not hard what I'm asking y'all to do, right? Talk to some lawyers, bring me the names of the lawyers. If you don't do that, then you run the risk of me putting you in jail. I would think if I had the risk of going to jail just for not talking to a lawyer or bringing the names of the lawyer, I'd make sure I did it and I brought those names. Do you remember at all who you talked to?
After I started doing the process of doing this job, I was trying to get the money for a lawyer.
But you don't know which lawyer you have or how much they charge if you haven't talked to any, right? Okay, so I'm going to reset your case one more time. You need to get a lawyer hired, or you need to talk to 3 and bring me those names. And that doesn't mean just calling their office. It means actually talking to someone, getting a quote to find out who can represent you. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. Tiffany Elair. Good morning. Are you Tiffany Elair? Miss Elair, did you get someone hired?
finally did get the check on Thursday, but I was waiting. I'm waiting on the bank to clear it because it was a large shit. Then yeah, I'll be about it.
Okay, so if I reset you 1 week, you'll be able to
Yeah.
get that taken care of.
Yes.
Okay, I'll reset you 1 week. Now, if you get him hired this week, make sure you bring the reset notice to you because if you've hired him, it has the ability to send something in and talk to us and maybe the next court date goes away for a different one.
Okay.
But plan on coming unless he tells you otherwise. Okay, step up. Is it Kyle Walker? Yeah, Kyle Walker. Okay, good. Thank you, ma'am. Darian Broussard. Good morning, you're Darian Broussard. And Mr. Broussard, were you able to get someone hired?
No, I was trying to, but he ain't accept my money because he don't take down payments. So I talked to 5 other lawyers.
Who'd you talk to?
I talked to Judge Walker. He take 3,000 down, but I was trying to bring 1,000. And I talked to Mr. Ross. He takes like 2,000 cash. I talked to what's his name? Kelly, Mr. Kelly, law firm. They want 5,000 cash.
Okay.
So I'm trying to go with like Mr. Ross.
Okay. Do you think you'll be able to save up and get that taken
Yeah.
care of if I give you, all right. Thank you for doing what I asked you to do. I'll give you one more reset. You can try to get Mr. Rojas hired. If that doesn't work, make sure you talk to some others and then we'll see what we can do next time. Javon Johnson.
He called.
He's in custody, Judge. We took her into custody on a misdemeanor warrant.
Oh, okay. Thank you. The misdemeanor warrant. I don't know. Maybe I'll just leave this one. Okay. Ronnie Lanza. Good morning. Are you Ronnie Lanza?
Yes, Your Honor.
And Mr. Lanza, were you able to get someone hired?
No, I was not. I was for a court appointed.
Did you talk to some lawyers?
The only person that I tried to go ahead and contact was Charlie Rojas. I don't exactly live near here. I live 4 hours away. And I definitely know that I cannot afford a lawyer.
Are you working?
I am working.
Where do you work?
Soda Pines Nursing Home and Rehabilitation Center.
Say it again, the first part.
Soda Pines Nursing Home.
Soda.
I'm a CNA.
Okay. And what are your hours?
I work an average of about like 48 hours a week.
Okay. Why did you only talk to one lawyer when I asked you to talk to 3 or ordered you to talk to 3?
Well, I wanted to go ahead and see how much I'm making. I have my pay stub. I get $500 taken out of each check for child support. I only make $15 an hour.
Okay.
And I have court fees from thing I'm on probation for already.
Where are you on probation?
I'm being supervised by Bastrop County, but it's originally in Medina.
Okay. For what offense?
Aggravated assault.
Is there a motion pending or anything based on this case?
No, I have everything here.
Okay. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, sir.
Okay, from the clerk. Corbin Rayleigh. Good morning. Are you Corbin Rayleigh?
Yes, ma'am.
And Mr. Rayleigh, were you able to get a lawyer hired?
No,
Who'd y'all talk to?
the same as last time, Crenshaw, Bearden. I don't remember the name off the top of my head, but I got the folders in the car. I just forgot it this morning.
Why would you have left it in the car?
It's Monday, I'm so sorry.
It's Monday?
Yes, ma'am, I'm sorry, I didn't mean to. It just tired this morning and stuff. I came in here.
So that's not, you understand how silly that excuse sounds,
Yeah.
right? We're all tired. It's Monday.
It's not really an excuse.
Okay.
Sorry.
Are you working?
Sometimes it's like maybe one or 2 days a week with my dad. He does contract business. Like
How old are you?
20.
So why aren't you doing something where you're working full time?
I'm waiting for this to be over, honestly, so I can.
Well, you can't wait for this to be over because you got to have money so you can hire a lawyer,
Yes, ma'am.
right? So that's what we've gone through before.
Yes, ma'am.
So you've got to follow the instructions that I've given you. You've got to talk to lawyers. You've got to actually try to hire them, and you've actually need to go get a job. I mean, it's great that you can work a day or two for your dad, but if it's not full-time, then you need to get a full-time job.
Yes, ma'am.
There's plenty of people out there that are accepting applications and hiring. I'm going to reset your pay for 30 days. You need to get a job within 30 days.
Yes, ma'am.
If you get one, bring a pay stub or something that proves that you got that job. If you don't get one, then you need to bring me every job, a list of every single one you've applied to. Do you understand?
Yes, ma'am.
You also need to talk to 3 lawyers so that when you do get a job and make some money, you'll know who you want to hire. Does that make sense? If you don't do all of that and bring that stuff to me, then your bond's going to be raised and you will go to jail.
Yes, ma'am.
Step in front of the clerk.
Okie dokie, folks. As I said, I had a few things I wanted to cover with you in the last part of the 4th hour, so we're going to do that real quick before we send you on your way for the day. Ellie, are you coming over to help? And Ellie's coming over to help. So everybody say good morning to Ellie. I got to have a seat though, sweetheart. I got to be able to see what I'm doing. First, let's start with what's going on with what we just saw in Judge West's court, because I looked it up. To see if there was any kind of restrictions in selling labor law posters in the state of Texas, and there is not. However, I did find that people are often charged there for selling them, and it has to most often do with impersonating a government official. So, for example, hold on a minute. So, for example, someone claims to be a Department of Labor inspector, a compliance officer, a government agent, something like that. And I located him on Judge's docket for this morning. So thank you, Ashley, for finding his name for me. He is charged with impersonating a public servant. So that's what's going on there. It has nothing to do, per se anyways, with the posters themselves. It has to do with how he is presenting himself when he goes to do it. So there we go. Okie dokie. I wanted to share a story with you real quick, and then I wanted to discuss Judge Boyd a little more. Hold on while I get this pulled up. Go here. So this was actually brought to my attention by Grandma TCF yesterday. It's a sad, sad story out of Gainesville, Georgia. High school teacher 40 dies when student's prank goes wrong days after district warned about stunts going wrong. Barbara, thank you for the $5. Good morning, Ellie, our beautiful co-host. I will put that in her Trito fund. Thank you. Georgia high school teacher is dead after an alleged prank went wrong just days after his school district warned students of past prom season pranks that went too far. Jason Hughes, 40, died late in the evening on Friday after he was run over at his Gainesville home by an 18-year-old who was pulling a prank along with 4 other individuals. 5 people, including Jaden Ryan Wallace, 18, covered or rolled the teacher's trees in toilet paper per the release. When Hughes came out of his home, the group got into 2 different cars to flee the scene. One of the vehicles was Wallace's pickup truck, with which he ran over Hughes after the teacher tripped and fell into the road. Wallace and the others involved in the prank stopped and attempted to aid Hughes until emergency responders arrived at the scene. According to the release, he later died at the hospital. Police arrested Wallace at the scene along with the 4 others. Elijah Tate Owens, 18, Aiden Hucks, 18, Anna Catherine Luck, 18, and Ariana Cruz, 18. They're all Gainesville residents. Wallace has been charged with first-degree vehicular homicide and reckless driving in connection with Hughes' death. He, along with the 4 others at the scene, have also been charged with criminal trespass and littering on private property. Hughes was a teacher at North Hall High School, father of 2 young boys, according to a GoFundMe fundraiser. Our hearts are broken, the district statement said. Jason Hughes was a loving husband, devoted father, passionate teacher, mentor, and coach who was loved and respected by students and colleagues. He gave so much to so many in numerous ways. Our hearts and prayers go out to him and his family. Oh yes, love me, thank you. Love me in the middle of a serious topic. Lighten up the mood a little. Yeah, so you're saying in the chat, heartbreaking story. What exactly did they do? Well, just to summarize again, Barbara, the students went to the teacher's house to TP his trees. Then when he came out to confront them, they got in their cars and started to speed away, but as he was pursuing them, he fell into the street and the one ran him over. So, you know, we talk a whole lot around here about wasted youth, and young people doing dumb things. And as Grandma TCF pointed out to me when she told me about this story, our young people do stupid things all the time. And you know what? I did too. When I was young, we all did. But I don't know that we're doing a good enough job of explaining to students and to young people just how close you can be to everything spiraling out of control. I've said it before, any of us are just a couple of missteps away from being in front of one of these judges that we see. And I don't think we do a good enough job of explaining to students, to young people, to our children, to anybody, how just a simple choice, that you look at and go, well, it's just a silly little thing, but it's one step closer to something really bad happening. It really is. Anytime you step out of a behavior that is labeled okay, you risk going further down the bad road. I'm just saying, I think we need to do a better job of teaching our youth to rethink their choices. I mean, stuff is still going to happen, but I worry that we don't do a good enough job explaining just how close you can be, how much closer you get to really bad things with go to this Judge Boyd situation. Now, we talked rather in Sidebar on Thursday about Judge Boyd and how she lost her primary and she'll be leaving the bench at the end of the year. And I posted that in a separate segment, and it's gotten a lot of comments, and it's interesting to me how polarizing she appears to have been, more so than I thought even. But it's interesting as well through some of these comments that I'm seeing how a lot of people I don't think are completely thinking out the process on stuff. That we're living in kind of absolutes. First comment was an hour ago. Good, she was a horrible judge. Another one, Boyd clearly enjoyed that moment in the trial where she gets to smack the defendant around. Really give it to the flawed human being at her non-existent mercy. I won't miss her. Good riddance. She was horrible. Then somebody else, she should do a Judge Judy style show. She was great until she became aware of her following. Once the Persons and Flowers came out, she was constantly looking into the camera. Not sure that I agree with that. She was terrible. If you're black, she lets you walk free. Bye-bye activist judge. And on and on and on, unfortunately. People are very much entitled to their opinion. And I'm not gonna deny somebody their opinion. Hold on here a minute. Why aren't you fixing yourself? This is weird. Hold on. New software, still learning. There we go. Okay. So people are certainly entitled to their opinion, and I'm not going to deny anybody their opinion, but I don't know that I can wrap my head around all of the negativity surrounding her that's come out. I don't know. Tell me if you see it differently in the chat. But yeah, as Michael said, I love how nearly all these comments don't give a specific example, or they give an example that's just not true, at least from what I've seen. And look, we watch a lot of court here. And I've told you before that I'm not somebody who is necessarily a Boyd fan. I've told you before that one of my problems with her is I felt like she was making up her mind often before she heard everything. I could see that. She's definitely opinionated. I didn't get the one where the person was claiming that if there was a black defendant in front of her, she treated them better. I definitely didn't see evidence of that. If nothing else, maybe a little worse. I don't know. But I was looking through those comments, and it was just disturbing to me because, again, I'm not necessarily myself the biggest Boyd fan in how she ran her courtroom. However, a lot of the allegations that I've been seeing, they just don't match reality. And I wanted to point that out because the majority of the morning audience, I think, is much more discerning than that. They're much more thoughtful. And I wanted to, if nothing else, thank all of you for that, because I believe that you look at things more critically. You have more thought put into what you see. And I think that's incredibly important. Because if we just look at moments and we don't look at the entire body of work of somebody, anybody, not just Judge Boyd, but anybody, if we're not focused on a full picture, I don't know how we can truly understand anybody. I don't know how we can truly work as a society. Any idea if any of these commenters are subscribed? So we're about 50-50, Lindsay, on subscribers versus non-subscribers that are watching that video. But I don't know, I can't tell just from looking at it if they're subscribers or not. But there are some names that I recognize. So yeah, I think some of them are. And that's fine. Like I said, you can have your opinions. I would just hope we would work better at grounding our opinions in facts and in real observations rather than these broad strokes that we see. And again, I wanted to thank all of you because I believe the people who attend the morning show are better than that. And that's one of the reasons why I enjoy the show so much. We can have good conversation that tends to be lacking on the rest of YouTube. So, but you know, you can go check out the video yourself. You can look through the comments, see what you think. But it's interesting, again, that she was so polarizing, but so few could point to exactly why, which I don't think serves us. Anywho, that is what I had for today, so we're going to go ahead and call it for now. We'll be back tonight on In the Blind, 7 p.m. Eastern, 4 p.m. Pacific. There's links that have been dropped in the chat for that. Be sure to check us out. That's not on this channel. That is on a different channel, a new show with me and Michael Groff. It has nothing to do with court, but it is super fun, so do please check us out there. We'll be back here tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier for channel members. I hope you all enjoyed the day. Thank you for joining me. It's been a blast, and look forward to seeing you soon. Take care. God bless.